ಅದು ಮಾಡಿ ಕೊಟ್ಟಿರೋದೇ ಅಷ್ಟು 2 ಇಶ್ಯೂ ತಾನೆ. ಶ್ರೀನಿವಾಸ ಟ್ರಸ್ಟ್ ಸಮಥಿಂಗ್. 3 ಇಶ್ಯೂ ಇಲ್ವೇ ಇಲ್ಲ, 2 ಇಶ್ಯೂ ಮಾತ್ರ ಪರ್ಮಿಟ್ ಮಾಡಿರೋದು. Reasoning is there in the order.
Your Lordship, the reasoning has have categorically held.
Those 2 issues only I have permitted.
On novation, your Lordships have held the previous paragraphs. Please, let me serve. My apologies.
I am aware. That's why those 2 I have extracted in the operative portion.
Please,
ಕೊಡಿ ಅಲ್ಲ GMCPC ಎಲ್ಲ ಕೊಡಿ. CRP Thursday GMCPC ಎಲ್ಲ ಕೊಡಿ. ಓನ್ಲಿ ಆನ್ ಸೀನಿಯಾರಿಟಿ, ಯಾವ್ದು ಪ್ರಯಾರಿಟಿ ಇಲ್ಲ ಇಲ್ಲಿ. ಎಸ್ ಅದು ಕೊಡಿ 230. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ. More than 9 months, not mine then, don't worry. Yes, we'll do it. ಯಾವ ವರ್ಷದ್ದು? Partition, of course partition, give it. Yes, we'll see, give it. Sorry. What do you want?
I'm challenging the execution proceedings. It is part 17 of RERA Act. The execution proceedings are filed before the sessions court. The RERA itself does not provide for.
All right, give it.
Your Lordship, end of the list.
Just matter ಇದೆ. Fresh matters. Wednesday if it is complied.
Your Lordship, for the end of the list, your Lordship, there is end of the list.
Why?
Your Lordship, there is urgency. Ex parte entry matter has been taken, your Lordship, to the strength of the police, your Lordship, they are trying to interfere. Your Lordship.
File an appeal.
Your Lordship,
MA.
There is no compliance of order 13 until.
No, file an appeal.
Your
Yes.
Lordship, through police, your Lordship, they are interfering.
Sir, nothing doing. Yes.
Your Lordship, there is no material.
If there is already an order passed, file an appeal. Yes.
Your Lordship.
Yes, next.
ತಾವು 2 ಸರಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಸ್ವಾಮಿ ಅವರೇ.
ಅಷ್ಟೇ ತಾನೆ, ಕೊಡಿ. 3ನೇ ಸರಿ ಕೊಡ್ತೀನಿ, ಕೊಡಿ.
ತಗೊಳ್ಳಿ ಸರ್.
Give it, give all the CRP memos and CPC memos kodi.
Land acquisition.
I am again telling you, no priority, only seniority. Yes.
Attachment warrant is issued, my lord.
Adu kodi 230 ge.
My lord, one matter, my lord, vacating stay, my lord.
Give it. All vacating stay memos you give. It will come, sir. Next week only, next Wednesday. Yes.
My lordship, fresh matter.
Give all the memos.
For fresh matter, my lordship.
8, 1 ನಿಮಿಷ. I'll come.
My lordship, fresh
Number
matter
8.
for allotment of alternative site, my lordship. Fresh matter, allotment of alternative site, my lordship.
Thursday, give it.
My lord, I filed an application for vacating stay,
Give
21
it.
matter.
My lords,
Give all the memos.
my lords, one fresh CRP matter, my lords.
Thursday, give it. Yes.
My lords, execution proceedings, my lords, sale deed. my
Yes,
lords, is-
execution proceedings 711 kodi. Yes.
My lords, it is not 711, my lords.
Then-
I had filed an application for resigning the contract, my lord. That application has been rejected.
We'll
Without
see.
considering, my lords,
Oh, nothing will happen.
my
Thursday,
lords,
yes.
for execution of sale deed, my lords, it is
So
posted.
ನಾಳೆ execute
My
ಆಗ್ಬಿಡುತ್ತೆ.
lords,
sir?
it is posted.
ಕೊಡಿ
to-
ಸರ್ ಸುಮ್ನೆ.
My lords, may I request-
Thursday, give it.
Thursday.
Yes.
Right.
GMCPC. You come give it. ಆ ಕೋರ್ಟಲ್ಲಿ ಹೇಳ್ತೀವಿ, ವೇಟ್ ಮಾಡಿ. ಮಿಕ್ಕಿದೆಲ್ಲ ಆಯ್ತಾ? ಕೊಟ್ಬಿಡಿ. ಶಿವರಾಮ್ ಸರ್ ಏನು ಮೆಮೊ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಅದು ಅಪ್ಲೋಡ್ ಮಾಡಿಸಿಲ್ಲ ಅವತ್ತೆ. ಏನ್ ಮಾಡೋದು, ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಬೆಳಗ್ಗೆ ಆಗಿರುತ್ತೆ. ಆ ತರ ಆಗಿದೆಯಾ ನೋಡೋಣ ತಾಳಿ. ಮಧ್ಯಾಹ್ನ ಕೊಡಿ, ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕ್ಸ್ತೀನಿ. ಯಾವ್ದು ತಗೊಳ್ಳಿ, ಕೊಡಿ ಮೆಮೋಸ್ ಕೊಡಿ. 8 ಕೋರ್ಟಲ್ಲಿ 8 ಆದ್ರೆ ಇರಿ, ಬೇರೆ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ.
My lord's matter for settlement.
ವೆನ್ ಡು ಯು ವಾಂಟ್?
Tomorrow.
ಅದು ನಾಳೆ ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ.
any day, my lord, before 18th, my lord.
Give it, sir. Yes. Vacating entry ಮಾಡಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ. ಕೋರ್ಟಲ್ 8 ದೇನು ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಸ್ ಮ್ಯಾಟರ್ ವೈ GMCPC ನಾ ಏನು 8 ಸೀನಿಯರ್ ಸರ್ವಿಸ್ ಮ್ಯಾಟ್ರಾ 8 ಇಲ್ವಾ ಇವತ್ತು ಸಿಟ್ಟಿಂಗ್? 8 ಇದೆ ಸಿಟ್ಟಿಂಗ್.
ಇಲ್ಲ ಸಿಟ್ಟಿಂಗ್.
ಓಕೆ 8 ಅಲ್ಲಿ ಸೀನಿಯರ್ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಮಾತ್ರ GM ಅಲ್ಲಿ ಇಲ್ಲ. GM ಕೋರ್ಟ್ಗೆ ಹೋಗಿ.
Service.
ಎಲ್ಲೇ ಬಿಡಿ ಅದ್ ಕೊಡಿ ಸರ್. ಎಸ್. ಟೋಟಲ್ 8 ಮ್ಯಾಟರ್ ಏನು?
Service.
ನಾಳೆ ತಗೊಳ್ಳಿ ಅಲ್ಲೇ.
My lord, one matter, my lord, total 8 matter, my lord, for being spoken.
ನಾನ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್. ನಾಳೆ ತಗೊಳ್ಳಿ.
Being spoken.
Mention.
No, I doubt tomorrow also is coming. But being spoken to ಅಲ್ಲೇ ಅವ್ರು ಇದ್ದಾಗ ಬರುತ್ತೆ ಬಿಡಿ.
Wednesday at least.
ಅದು ಯಾವಾಗ ಬರುತ್ತೆ ಅವ್ರ ಮೂವ್ಮೆಂಟ್. being spoken to ನನಗೇನು ಅರ್ಜೆನ್ಸಿ? ವಾಟ್ ಇಸ್ ದಿಸ್?
Total 8.
ಟೋಟಲ್ 8 ಏನು?
Fresh memo.
ಆಯ್ತು.
ಕೊಡಿ ನಾಳೆ ಕೊಡಿ. CPC ಕೊಟ್ಬಿಡಿ ಸರ್. ಕೊಡಿ ಸರ್. 2:30 ತಗೊಳ್ಳಿ.
Total 8 matter.
ರುದ್ರಪ್ಪದು 2:30 ತಗೊಳ್ಳಿ. ಟೋಟಲ್ 8.
Compassionate.
Total 8.
8. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ. ನೋ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೆಕ್ಸ್ಟ್ ನೀವು 10 times ಮೂವ್ ಮಾಡಿದ್ರು ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಗಿವ್ ಇಟ್ ಗಿವ್ ಇಟ್. ಎಸ್.
Total 8.
Kindly list on Wednesday. There is an urgency. She met with.
ಟೋಟಲ್ 8 ದಾ?
8. Service matter.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ನಾಡಿದ್ದೆ ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ನಾಳೆ ಅಲ್ಲಿ ಬಂದ್ರೆ ನೀವು ಕೊಡಿ ನೋಡೋಣ.
Please, madam, there is an urgency.
8th ಕೊಡಿ. 8th ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಅದೇ ಪರ್ಮಿಷನ್ ಏನ್ ಬೇಕು ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಬರುತ್ತೆ ಸರ್.
Total number 8 matter.
8 ತಗೊಳ್ಳಿ. 8th ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ ನೋಡ್ಬಿಟ್ಟು ಹಾಕೋಣ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ, ಸುಮ್ನೆ ಕೊಡ್ಬೇಡಿ. And total 8th list today, I'll take it at 2:30. Nobody need wait for that now. ಅದ್ರಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕು ಅಂದ್ರೆ 2:30 ಹೇಳಿ.
CPC matter, 24 matter, fresh matter.
Next Monday.
Serial number 72.
Which list?
First list, my lord. This court.
No adjournment. Yes.
No, it is my lord.
No adjournment.
I have informed other
Mentioned.
connected matter.
We'll grant it, but not at 10:30. Yes.
My lord, list number 2, my lord, I'm withdrawing the petition. my lord.
Serial number 2, this court's list. Yes.
GM-RES and total ಎಂಟಿಕೆ ಬರುತ್ತೆ.
GM-RES ಜಸ್ಟಿಸ್ ಸುನಿಲ್ ದತ್ ಯಾದವ್ ಸಾಹೇಬ್ರ ಅವ್ರು ಇದಾರೆ, ಹೋಗಿ ಸರ್.
List 1 being spoken to. Number 1.
Password. Yes.
Order seal number 2.
Blood. Serial number 124 ಎನ್ನ ಸ್ವಲ್ಪ ಪ್ರಯಾಣ.
ಗೊತ್ತಾಯ್ತಾ? ತಗೊಂತೇನೆ.
ಅದು 124 ಕೊಟ್ಟೋಗ್ಬಿಟ್ಟಿದೆ ಇವತ್ತು. ಅದಕ್ಕೆ
ಏನ್ ಅದು ಎಷ್ಟು? ವಿಲ್ ಸಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್. ಎಸ್, ಬಿಫೋರ್ ದ ಎಂಡ್ ಆಫ್ ದ ಡೇ ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್.
ಪ್ಲೀಸ್.
ಎಸ್, ನಾಟ್ ಮೇಂಟೈನಬಲ್.
ಅಲ್ಲ, reason why it is maintainable.
GMCPC ಹಾಕಿ, not CRP.
No, GMCPC is not maintainable. For this reason, my lord, disposal of 7 Rule 10 application.
It is allowed, is it?
It is rejected now. If the
Rejected ಅಂದ್ರೆ
application
ಇಲ್ಲೇ
is
ಇದೆ
allowed,
ಬರ್ಬೇಕು. ಇದಕ್ಕೆ
the suit will be disposed of.
No.
So it comes under 115.
application is rejected.
Application
Office
is rejected.
objections square maintainability stands overruled. Yes, no,
Because, in this.
no merits, wait. Will only issue notice. Reject ಆಗಿರೋದ್ರಲ್ಲಿ ಏನು entry ಮಾಡಿ.
ಇಲ್ಲ, the reason why I am seeking
What
an
is the
interim order-
ground?
My lord, the ground is this, my lord, that the.
Commercial OS ಬರಲ್ಲ ಅಂತನಾ?
ಅಲ್ಲ, ಕಮರ್ಷಿಯಲ್ OS ಬರಲ್ಲ ಅಂತ ಅವ್ರು ಏನಕ್ಕೆ ಹೇಳೋದು ಅಂದ್ರೆ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ನಾಟ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ ದಿ MOU ಅಂತ ಹೇಳ್ತಾರೆ. But in the plaint, they explicitly say that Schedule A as well as B property are
It is now being tried as a regular suit.
regular suit. And I have filed a counter suit before the commercial court wherein they have not raised any objections. The respondent have appeared.
Petitioner to serve on the counsel representing the respondent plaintiff before the concerned court and file an acknowledgement to that effect, lest the matter on 24 till such time further proceedings before the concerned court shall remain state. Next.
Grateful.
3.
I appeal for the petition. This
Post immediately after service of notice upon respondents 3 to 5.
one request. my lord.
Rectification
My lord,
3, 4 and 5.
in serial number 3.
Rectification 3 alla.
Serial number 3, my lord.
Oh, sorry, this is non-compliance.
My lord, objections have been complied. Re-scrutiny ಇದೆ.
Mic ತಗೊಳ್ಳಿ. Comply ಮಾಡಿದ್ದೀರಾ?
Please, my lord.
Learned counsel submits office objections have been complied with. Office to verify if they stand complied, list day after tomorrow in preliminary hearing.
Grateful.
Next.
4.
4, post immediately after service of notice upon 3, 4 and 5.
Substitute to bring LRs on record.
Where is it?
I have filled an application, substitute application.
Comply
It is
the
report-
objections.
It is reported as expired. I've substituted.
Comply the objections in that application, sir.
Please.
A week's time to comply with the office objections on IA 1 of 2025.
Date may be.
Put up immediately after compliance. Yes,
Milords,
next.
in this case, Milords, I had moved this matter.
Neva.
ಹೌದು. Serial number 5, Milords. The surface, against the surface proceedings, civil suit was filed by the plaintiff.
How is it maintainable?
That's what Milords, so they declined interim order. So in this present writ, this court told not to alienate.
Oh, this is not mine.
Yes. Not mine. I'm seeking only clarification, Milords. Your Lordship has said, the court bench of this court has
This
told.
suit is not maintainable at all. How is it
Absolutely,
even?
absolutely.
Yes. Pass over ಮಾಡಿರ್ತೀನಿ.
Published.
ಬರ್ಲಿ.
Here for the petitioner, I have served a copy.
Counsel for the petitioner submits needful has been done, office to verify. Enter ಮಾಡಿದ್ಯಾ? Enter order subsisting will continue to the next date of hearing. Next. Need, same order.
8.
Non-filing, where's the acknowledgement?
2 days, kindly be time granted.
Will, enter ಮಾಡಿದ್ಯಾ? Sir. Counsel seeks a week's time to do the needful. Yes, next. A week's time is granted to do the needful. Next.
9.
Matter is settled. Next week I will report the settlement.
Current counsel for the petitioner submits matter has been settled between the parties. Would seek time to report settlement. List on next Friday, Hakla?
Next Friday.
25th to report settlement at 2:30 PM.
Interim order.
Interim order subsisting would continue to the next date of hearing. Next.
10.
Served the council on the 10th minute today, I will file the acknowledgement.
Interim order ಇದೆಯಾ?
ಇದೆ sir.
Vacate ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ 10th ಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
Acknowledgement ಯಾಕೆ ಹಾಕಿಲ್ಲ?
ಅದು ಇವತ್ತು ಹಾಕ್ತೀನಿ sir. ಇವತ್ತು
Counsel for the petitioner
Served on
seeks,
10th.
submits that he would do the needful in the course of the day. In the event needful is not done in the course of the day, the interim order subsisting would automatically get vacated. Next.
11.
Compliance with the office objections. A week's time is granted to comply with the office objections.
12.
A served copy to the Torchilla.
Furnishing PF,
ಅಲ್ಲ, served copy ಮೇಲೆ.
ಏನ್ served copy order ಏನಿದೆ?
ಅದೇ served copy to the counsel advocates in the lower court. I served and filed the acknowledgement also.
You have filed ವಕಾಲತ್?
ಇಲ್ಲ ಬಕ್ಕಲ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ತೀರಾ? That-
3 weeks time maybe.
Oh, yes,
They are
sir.
outside,
Yes, sir. Learned counsel so and so, Jose Sebastian,
Yes.
undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. He would seek 3 weeks' time to file statement of objections. List
Stay
the
may
matter.
be- Interim order may be extended. Already given.
No, I have not granted. List the matter after 4 weeks. Interim order subsisting will continue to the next date of hearing.
Please.
13.
R1 to R6. A week's time is granted to do the needful. Next.
14.
I undertake to file wakalat.
Learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent.
For respondent number 4 and 7. they are-
4 and 7. In the ಮಿಕ್ಕವರಿಗೆ 2, 1, 2, 3
It has been dispensed for 1, 2, 3.
dispensed. All right, yes.
5 also.
Or dispensed with, yes.
6, I think someone else is appearing for 6.
Who is appearing for 6? So and so. 6 ಆಗಿಲ್ವಾ, dispense ಆಗಿಲ್ಲ. List the matter after service of notice upon the 6th respondent.
6th respondent already served, my lord.
I had appeared for respondent number 6 in the trial court, but in the high court, respondent number 6 told me that he's going to engage another counsel.
Oh, yes.
So I'm appearing for 4 and 7 in the, before the high court. Your Honor.
4 and 7.
4 and 7.
Learned counsel so and so enters appearance for 4 and 7, awaiting the appearance of respondent number 6, awaiting, list the matter on 23rd. Interim order subsisting will continue.
There is no interim order.
There is no interim order.
Ah,
my
that
lord.
will-
ಅದರಲ್ಲಿ my lord, matter is posted before the trial court on 24th, my lord.
By mistake ಹೇಳ್ಬಿಟ್ಟೆ interim order subsisting. ಪರವಾಗಿಲ್ಲ. 23rd, yes.
15.
Copy of a petitioner, please.
On filing of acknowledgement,
I have served.
learned counsel,
1 to 3, I undertake to file.
1, 2, 3.
Please.
ಇನ್ಯಾರು ಇನ್ನೆಷ್ಟು ರೆಸ್ಪಾನ್ಸ್ ಇದ್ದಾರೆ?
I am appearing for respondent number 6, 7, please make.
I've served all the respondent.
1 minute, ಅವರೇ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. Learned counsel, so and so undertakes to enter appearance for
R1 to 3.
R1 to 3. ನೀವು
Respondent number 7.
R7, ಇನ್ಯಾರಿದ್ದಾರೆ?
1 to 3 is the judge, decree holder, please lordship. They have appeared already.
ಆಲ್ ರೈಟ್. ಇನ್ಯಾರಿದ್ದಾರೆ?
ಇನ್ನು ಬೇರೆ ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. I have served the
ಸರ್ವೆಲ್
notice.
ಆಗಿದೆ.
I have served the notice also.
The learned
7 also
counsel-
served.
The learned counsel submits. Where is the acknowledgement?
Acknowledgement I have already submitted before the
When?
registry, please lordship.
When?
It is submitted.
Counsel
on-
for the petitioner submits
Paid up.
acknowledgement of such service has already been filed before the
My
registry.
humble submission. please, in
Registry to
this case.
verify. Based on.
R1 to 3, they have obtained the attachment order, please lordship. It is my humble submission as per the compromise decree.
List on Friday in preliminary hearing. Yes.
Grateful. Lordship.
16.
ನೀವೆಲ್ಲಿದ್ರಿ? ಇನ್ನೊಂದು ಯಾವ್ದು? ನಿಮ್ದಲ್ಲ ಬಿಡಿ. ಸಾರಿ. Yes.
My lord, I have filed the receipt for service of the copies to the respondent.
Learned counsel submits needful has been done, office to verify. Entry order.
Our office objection is we have not yet furnished the
Entry
acknowledgement.
order ಇದೆಯಾ?
Entry matter.
Entry order subsisting will continue till the next day.
Acknowledgement, my lord, we will furnish in due course.
ಮಾಡಿ.
ಇಲ್ಲ, ಬಂದಿಲ್ಲ ನಮ್ಗಿನ್ನು ವಾಪಸ್.
ಸರಿ ಆಯ್ತು.
17.
Lord petitioner's lord. Lord, in this case,
File an appeal, sir.
Lord, I'm not a party to that.
You are not a party ಅಂದ್ರೂ ಫೈಲ್ ಮಾಡಿ.
I'm not party and moreover the
Not a party to what, sir?
suit, Lord.
Why are you challenging it?
What has happened, Lord?
Order 1 Rule 10 reject ಆಗಿದೆಯಾ?
Illa, plaintiff has sold the property to me
When?
after filing the suit. And after that, intermatter has.
Suit for
partition.
come in the FDP. Yes. Anything else?
Lord, I'm for the petitioner,
Are you the family member?
not a family member.
Then yes.
My lord, what
If you are a purchaser after the institution of the suit for partition, come in the FDP, not in.
What has happened, Lord? The plaintiff and the defendant both sells the property. And after
So
that,
what?
Lord, what has happened? After that, the defendant produced the sale deed saying that we have sold the property to petitioners. After that, temporary injunction has been confirmed, Lord. Not to alienate. Not to alienate antandre, it is affecting me because I have applied for the conversion and the Muda has issued a notice. I have purchased the property.
Not to alienate, ಯಾರು ಕೇಳಿರೋದು?
ಅವ್ರು ಕೇಳಿದ್ದಾರೆ, ಯಾರು plaintiff. But after ಕೇಳಿದ ಮೇಲೆ plaintiff himself sells the property.
Serve on them then. Yes.
Lord, what has happened, Lord?
Interim model ನಿಮ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಕ್ಕೆ ಏನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Construction ಬೇಡ
ಅದನ್ನೇ ಮಾಡೋದು ನೆಕ್ಸ್ಟ್ ನೀವು.
ಇಲ್ಲ alienate
No.
ಅಲ್ಲ, not to alienate
ಸರ್ವ್ ಮಾಡ್ತು ಕರ್ಕೊಂಡ್ ಬನ್ನಿ.
ಅಲ್ಲ, ಏನಾಗುತ್ತೆ
Petitioner to serve on the counsel who represents the respondents before the concerned court and file an acknowledgement of such service by Wednesday. List the matter. If service is complete, list the matter on 18th.
Mission, Lord, not to alienate ಅಂತ ಅಷ್ಟೇ ಅಲ್ಲ, ಏನಾಗಿದೆ ಅಂದ್ರೆ suit becomes infructuous as far as my property.
Let them come, sir.
Plaintiff, Lord,
ಈಗ ಏನ್ ಬೇಕೀಗ?
ಅಲ್ಲ, ನನಗೆ
ಏನ್ ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ, ಎಲ್ಲಿ not to alienate ಅನ್ನೋದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ಎಲ್ಲ
ಅದು ಮಾಡಲ್ಲ. Without hearing them, I will not.
ಎಲ್ಲರಿಗೂ ಬೇಡ, ನನ್ನ ಪ್ರಾಪರ್ಟಿ.
Without hearing them, I will not.
Kindly see them, Lord. Kindly see page number.
I will not. List on Friday. Get them.
ಸೇಲ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
There is an order.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಮಾಡುತ್ತೆ, ಅದನ್ನ ಇಂಪ್ಯೂಟ್ ಆರ್ಡರ್ ಅಲ್ಲೇ ರೆಕಾರ್ಡ್ ಮಾಡುತ್ತೆ.
ಈಗ ಫ್ರೈಡೆ ವರೆಗೆ ಏನಾಗೋಗುತ್ತೆ?
ಲಾರ್ಡ್, ಏನಾಗಿದೆ, ನಾಳೆ
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಸೇಲ್ ಡೇಟ್ ನ?
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಲ್ಲ, ಮೂಡಾದವರಿಗೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. You have purchased the property during the interim order ಅಂತ ಹೇಳಿ. I have not purchased. See, I have purchased from the plaintiff himself.
ಮೂಡಾ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ ಶೋಕಾಸ್ ನೋಟಿಸ್?
Lord, kindly see. ಅಲ್ಲ,
yes,
at least till appearance.
Yes, Friday. If you want this Friday or next Friday?
ಇದೇ ಫ್ರೈಡೆ.
sir. Yes, next.
18.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. We'll hear them and pass orders. Without hearing, I will not. Yes, next.
18.
Petitioner, I have served the copies on the other
Learned
side.
counsel for the petitioner submits needful has been done, office to verify.
19.
Interim order.
Subsisting. What is office objection?
19. You cleared the office objection. This is suit for defamation.
It's a good name anyway, bid and hammer.
We are an auction house, my lords.
Office objections ಏನ್ madam?
Prayers were not clear was the only office objection.
Not
Again,
clear.
Not clear because, so we filed an
Not
application.
legible or not clear?
Not clear. So we filed an application in the suit, my lords, under 39(2)(a), which got converted into a mispetition instead of an IA. So we said mispetition in OS
So they said that is not coming out in the order and there is no order as such. It's just become a new mispetition.
All right.
Only to that extent,
Now what is under challenge?
we filed an IA under 39(2)A, my lords. Now, we had an auction coming up on Friday, 11th. There were 78 links that were visible to people. And we have a favorable order, which says that these links should be taken off by Google. Google is the other party. In the search engine, all these prompts are coming up. We've been trying to file an application under 39(2)A even before vacations. 3 times my advancement gets rejected.
Serve on Manu Kulkarni. Google Matrana Bere
Google Matra.
For the fifth respondent.
Please, madam.
Petitioner to serve on office objection, accepting the submission of the counsel with the petitioner, office objections overruled. Petitioner to serve on Manu Kulkarni, representing the fifth respondent with requisite set of papers in the course of the day. List the matter on Wednesday in preliminary hearing.
Great.
Yes, next.
20.
Counsel submission.
For the petition, the office objection is that preamble to the orders have to be placed on record, my lord.
Overruled Wednesday preliminary hearing.
Yes.
ಏನು urgency ಇದೆಯಾ?
Police protection challenge ಮಾಡ್ತಾ ಇದ್ದೀವಿ Wednesdays.
ಆಯ್ತು Wednesday. Yes.
Yes.
Preliminary hearing 21.
Yes, I'm for respondent.
I appear for petitioners, my lords. Seek for a short
No,
adjournment, my lords.
petition will be infructuous, my lord, because
My
thing is
lords,
that-
sir, we're filing
ಈಗಲೂ
appeal in the high
infructuous.
court.
because my lord,
Appeal in the high court, my
ಎಲ್ಲ
lords.
ಅಲ್ಲ ಈಗ ಹೈಕೋರ್ಟ್ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇರೋದು?
pending has been disposed of
ಯಾವತ್ತು?
on 3/7/2025. I filed memo and also produced a copy.
What is the order?
The writ petition came to be allowed and set aside the order in favor of the petitioner hearing.
Anything else, sir?
My lords, we're filing appeal in the high court, so kindly.
Filing appeal in the high court?
Kindly seek.
Or
for a
writ
short-
appeal?
Appeal.
That will not stop this court, madam. Anything else, madam?
A short adjournment, my lords.
Tomorrow? Yes,
Please, please.
please tomorrow.
Preliminary hearing.
22.
Pass over.
23.
Transfer should have been to the
Yes, ma'am.
senior division, not junior division.
junior division.
Correct.
So,
Heard so and so, emergent notice to the respondent, but petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement by Friday. List the matter on 23rd. Further proceedings before the order dated so and so, and all further proceedings taken there too shall remain stayed. What's your name? What's your name?
Gautam, my lords.
Yes, next.
24.
For petitioner, my lord. Petitioners are the defendants, my lord.
First appellate court order 24/7/2024.
My lord, they have filed the 3
Notice,
IAS, my lord. They have
notice,
filed
notice.
the emergent notice.
39-1 rejected.
3 ಐ ಹಾಕ್ತಾರೆ, 3 ಐದಲ್ಲಿ 3 ರಿಜೆಕ್ಟ್.
ಪರವಾಗಿಲ್ಲ, ಎಲ್ಲ 24ರಲ್ಲಿ ಆಗಿರೋದು, 1 ವರ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ 2 ಐ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ, ಅದರಲ್ಲಿ 1 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. 1 ಐ ಮಾತ್ರ.
You serve on the counsel.
Yeah,
Petitioner to
release
serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement by Friday. List on 30th. Yes, next.
25.
Also, I appear for the respondent in this matter.
Medical supplies ಅವ್ರು ಬರಲ್ಲ ಬಿಡಿ. ಯಾವ ಕೇಸಲ್ಲೂ ಬರಲ್ಲ. No representation by the petitioner. List after 2 weeks. Next.
26. The petitioner, my lord. My lord, this is a writ petition challenging an order rejecting my application seeking disclosure of assets on affidavit. I'm an award holder, my lord. I filed an execution petition in Bangalore. After the execution petition was filed, they dissipated their movable assets as admitted by them. Thereafter, my lord, when I filed my application seeking disclosure of assets on affidavit, they came forward and just filed a memo saying that they have surrendered the lease in Bangalore. Therefore, the Bangalore court has no jurisdiction.
What do you want now?
My lord, I want them to file their assets affidavit seeking affidavit of
What
assets.
is the decree?
My decree is an award, my lord. I am a consultant.
What is what is the amount?
About 60 lakhs, my lord.
Yes, sir.
They have already filed an execution in Thane.
Oh, pending.
That's pending. Then they file an execution here. On the basis, my lord, there's some leasehold property of mine here, so that they can get an attachment of movables. That lease thereafter was surrendered, and therefore there's no property within the jurisdiction of this court.
No, lease surrender, leasehold property or your own
It's
property?
not my property.
Then how
Some
can you
lease which I
attach
had
that?
taken, I've surrendered. There's no jurisdiction in the
Attach-
court today.
How can you get
I
that?
was seeking to attach the movables, my lord, and the
No,
date.
movables.
Movables, my lord. I'd first sought for attachment of garnishes.
Now there is no lease.
My lord, they have taken other, I'm sure they've taken another office because they're also advertising,
That affidavit will file, we have no assets within the jurisdiction of this court.
my lord, what is the
Not a
difficulty
memo,
for them?
an
I'll
affidavit.
file an affidavit.
Let him
Lord,
file
let
an
them file
affidavit.
an affidavit saying that what their assets are, my lord.
Let
because
them
That
file it.
is a jurisdictional question. All over the country,
My
they
lord,
want to know what
that
the
will-
assets.
If I may just,
But-
file-
That can't be done.
I will direct them to file an affidavit here, they will file.
my lord, let them be directed to file all their assets, my lord,
No,
not just the.
that is like allowing the
My lord,
application.
Bangalore is-
All over the country.
Please, my
Yeah.
lord, under order 21,
Mobiles,
rule
correct.
41, they are required to file their assets as on date of all the assets that are there all over the country. And
No, no, no.
What are you?
Bangalore is the seat
I am a
of.
company.
Hmm.
I am in Thane. There's a proceeding in Thane. They don't move an application there, which has
21
jurisdiction.
2141
Yes.
directs payment of filing of complete assets and liabilities.
That is true. That is if the proceeding is within the
Within
jurisdiction
the
of the court.
jurisdiction ಅಂತ ಎಲ್ಲಿದೆ?
How though? Without that, you can't just
My
file
lord,
anywhere. There's an
jurisdiction
order.
is
of the-
reckoned as on the date I'm filing. When I
No,
file my
it's not
execution
so.
petition, admittedly there these were.
Wait, madam.
Apologize.
Yes.
Can I request, there's one judgment directed on this point.
ಕೊಡಿ.
Manganese ore. And that's what the learned judge has considered. Everything,
ಹೊಸ ಎಲ್ಲ ಹಳೇದ?
Allah, nowadays no one's writing on all these things, unfortunately.
Yes, yes.
Please see para 11.
Hmm. And not against the property situated within the jurisdiction of some other court.
Because ultimately to invoke jurisdiction of a court, whether for execution of original proceedings,
It appears to be, let me see.
it has to be, my lord, because otherwise you can file anywhere you want and then say you must disclose. It's not a case where there's no other execution pending. There is an execution pending where
What has happened there?
they're not moving it. They've just left it as it is.
But for 2 years, they sought time to file objections. I have just a few citations I wish to place on record on two issues, my lord. First, that Bangalore being the seat court can never lose jurisdiction, regardless of if there were no assets. Second, my lord, the jurisdiction is reckoned as on the date I file my execution. The date I file my execution, admittedly, they cannot deny that there were assets within the jurisdiction. They surrendered their lease 1 day before the application seeking attachment of mobiles. Therefore,
Where
my
is,
lord,
how do you say that they're advertising and they are still in?
my lord, I have not placed those on record. There were posts on LinkedIn and they were also orally reaching out to employees seeking for employment in Bangalore.
So
I have many sister concerns.
File your
my lord.
affidavit, we'll see.
Let them file
Anyway,
all
there's
their
an
assets,
interim
my lord.
order here.
My lord, the interim order is that the execution court does not dismiss the application in the meantime.
There's nothing else in the
The
execution to be
petition is
done.
pending, my lord.
You
because
can't
then again
proceed.
notice will
Where
have
will
to
they
be
proceed
issued
against?
Learned counsel for the petitioner is before this court calling in question an order rejecting an application or order 21 rule 41 in an execution in the execution subject execution proceedings. The learned counsel for the petitioner submits that the respondents judgment debtors have to declare their assets in its entirety or wherever they are doing their business, which is disputed by the learned senior counsel representing the respondent, contending that the assets are to be declared only within the jurisdiction of the court.
I'm not saying that.
Mata?
I am saying, my lord, that the question of how jurisdiction starts in a particular court is if there are assets within the jurisdiction of the court. That's the only way, my lord.
We'll see, we'll answer it.
That's
Yes.
what I'm saying. Therefore,
We'll
that
answer
you lordship will have to examine.
Don't print that, Javai. So the learned counsel for the learned senior counsel Dhyan Chinnappa representing the respondent would however dispute it. The learned senior counsel is the advocate on record shall file the complete assets of the respondent judgment debtor by way of supported by an affidavit by the next date of hearing.
That is not allowing the writ petition. Might as well allow the writ petition.
Affidavit hake.
No, that is the application. Application is to disclose assets, which is what we are saying we can't.
So you're not going to disclose the assets.
I'm only pointing out to the court that I have no assets within the jurisdiction of this court.
Jurisdictional issue will decide.
That your lordship may have to decide first, Lord,
Day
because
after
then it's allowing the
Lord,
application.
let them file the affidavit.
Day
If
after
there are no
tomorrow.
assets in Bangalore, I cannot seek attachment here.
That's
Wait.
okay.
He has a point, we'll see. List day after tomorrow. What are your judgments? Give it. 2141 judgments? Yes, madam. Are the interpretation of 2141?
Please, my lord, there is one on the date of which the jurisdiction is considered
We'll
and the
see.
other is on the seat
We'll
court
see,
continuing to
yes.
have jurisdiction.
Day after tomorrow.
Right.
27.
I appear for the respondent in this case, my lord. Copies are served on Friday, my lord.
And
Some more time I
divergent.
require. Friday they served the copy, my lord.
Anyway,
I-
1 year back it's happened, yes. The learned counsel appearing for the respondent submits the copies of the petitioner served days ago. List the matter on 23rd, objections if any by then. Next. 30th, sorry. Objections if any by then. Next.
28.
The petitioner, my lord.
I appeal for third respondent, my lord.
Compromise matter.
Partial compromise. ಯಾರು ನೀವು ಯಾರಿಗೆ?
I appeal for third respondent, my lord.
Learned compromise ಯಾರ್ಯಾರ ಮಧ್ಯೆ ಆಗ್ತಾ ಇದೆ?
Defendant number
ಅಲ್ಲ
192.
ಆಗಿಲ್ಲ ಅದು ಈಗ my lord rejection of compromise is under challenge.
Partial compromise rejected.
Yes, my lord.
Between
1 and 2.
which plaintiff and which defendant?
Plaintiffs and defendant number 1 and 2.
Defendants 1 and 2.
He's
You are
defendant number
what?
3.
I am third defendant, D3.
You are objecting to that?
Yes, my lord.
Yes.
My lord, I have filed an application seeking a vacation of interim order. For the reason, my lord, they are constructing a building in the disputed property. My lord, when I filed an application before trial court.
Suit for?
My lord, suit for rectification.
Execution of rectification.
What rectification?
They had executed a sale deed in my favor. The issue with the boundary. And
But-
therefore I had filed a suit for calling upon them to execute a rectification deed, correcting the boundaries in the sale deed.
The boundaries were erroneously printed in it?
It's my contention the boundaries were wrongly printed.
Hmm.
They rejected.
When was the sale deed?
98,
1998.
1998.
Yes.
Between whom?
Between the plaintiff and all the defendants.
All the defendants. Other defendants are agreeable.
Now they are agreeable.
What's
Defendant
your
number
problem?
My lord, 1998 sale deed came into force. Then 2004 there was a rectification deed.
Oh, this is second rectification?
Yes, my lord, they are seeking second time. Moreover, my lord, under section 26 of the
My
specific
only
criminal fact.
contention is.
Why?
My only contention is this, my lords. The defendant number 1 and 2 have come forward for execution of the rectification deed. I'll contest the suit insofar as defendant number 3 is concerned. I am not saying I don't want to contest the suit. Now defendant number 1 and 2 have said, okay, I'll execute the rectification deed in your favor and I agree that the boundaries are wrong. Insofar as defendant number 3 is concerned, I'll contest the suit and I'll fight it out, my lords. I have no.
Partial
qualms.
compromise can
No, my
happen.
lord, but
No,
in the-
you can't stop partial compromise.
my lord, in the instant case, the nature of compromise.
Whatever nature, partial compromise between the parties, you can't stop it.
Like even, my lord, suit itself is not maintainable. Under section 26, my lord, there must be ground that they're fraud or a mistake. They have not stated anything. My lord, moreover, they have, my lord, they have agreeing to give a site for him. Therefore, they have entered into a compromise. That is not a lawful. Even if that compromise is accepted, your honor, it is impossible to satisfaction.
ನಿಮಗೆ ಸೈಟ್
ನಮಗೆ ಬೇಕಾದ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು
ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್.
ಅದಲ್ಲ ಇದೇನಾಗಿದೆ ಮತ್ತೊಂದು ಸ್ವಾಮಿ ಏನಾಗಿದೆ, ನಮ್ದೇ ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಬೇರೆ ಸರ್ವೆ ನಂಬರು, ಬೇರೆ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಪ್ರಾಪರ್ಟಿನೇ ಬೇರೆ ಇದೆ. ಈಗ ಏನ್ ಬೈ ವರ್ಚ್ಯೂ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡೋರ್ ಮೇಲೆ ದೇ ಆರ್ ಕನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ದಿ ಬಿಲ್ಡಿಂಗ್. But let there be an interim order. I have no objection. But trial court, my lord, is not considering our application for the reason that the entire proceedings has been stayed. Your honor, lordship may kindly appreciate. Let them stop the construction. Let there be a decision.
Application is pending there, they will, you contest that.
Yes, my lord. At least I may be, trial court may be directed to consider our application.
1 and 2, yeah.
My lords, I'll seek dispensation against the 1 and 2 because they have agreed to make a settlement, my lords. They're not necessarily parties.
We'll direct the court to consider the application notwithstanding the pendency of this petition.
The matter will be disposed of. Insofar
Yes,
I
my
am
lord.
concerned, my lords, the settlement can be accepted. I'll contest the suit.
But for the reason, my lord, kindly appreciate.
In fact, my lords,
That
this concern-
compromise cannot be executed at all. For the reason, my lord, thrice there is a.
That the court will decide.
Yes, my lord. That I will, I have no objection. But now present, my lord, by virtue of interim order.
I will do this. I will direct the court to consider the compromise in accordance with law. As partial compromise is permissible. All right. And I will direct the application filed by the defendant number 3 to be heard on its merit.
But in the meantime, let them not do anything.
Alli.
Page 20.
Alley maintain status quo at least. Lord, if for consideration, it will take some time. In the meantime, if you completed the entire.
I will direct the court to consider it in 15 days.
Page 21.
My lord, till that, my lord, they are already putting up the pillars, my lord. They will complete it within.
15 days will complete.
How the Swami?
Oh,
Hello, they wanted to do that, but I will show the photograph.
21.
ಏನು ಪೌಲ್ಟ್ರಿ ಕಟ್ತಾ ಇದ್ದೀರಾ?
House.
ಹೌಸ್ 15 days ಅಲ್ಲಿ ಮುಗ್ದೋಗುತ್ತಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಈಗಾಗಲೇ ಕಟ್ಟಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪಿಲ್ಲರ್ ಹಾಕಿಬಿಟ್ಟು ಇನ್ನೇನ್ ಒಂದು ವಾರದಲ್ಲಿ ಮೋಲ್ಡ್ ಹಾಕಿಬಿಟ್ರೆ ಆಮೇಲೆ ಮತ್ತೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ.
ಅದೇ ಮನೆ ನೀವು ತಗೊಳ್ಳಿ.
ಆಮೇಲೆ ದಯಮಾಡಿ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಆಗೋ ತನಕ ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿ ಸ್ವಾಮಿ.
ಈಗ rectification, sale deed ಯಾರ್ಯಾರ ಮಧ್ಯೆ ಆಗಿದ್ದು?
Plaintiff and defendant, all the
No,
defendants.
no.
Even he's a
His
party.
father or what?
Also,
Him only.
him only. The defendants and plaintiff.
Her only.
Defendants, 3 defendants and plaintiff were parties to the sale deed. Then, my lord, 2005, they obtained a
Their
rectification.
contention is not that
Hello,
now,
my lord,
now they set up a claim.
Let me complete. My lord, in 2004, there was a rectification deed. Again, my lord, even now after lapse of nearly 10 years, the suit is filed. Without saying anything, without disclosing what is the reason, which should be rectified, what boundary is correct. Lord, there is no clarity in the plain. Lord, at least there must be reasons, then the court will appeal the discretionary, Your Honor, under the relief, specific relief acts, the discretionary one. Even if they have obtained compromise, my lord, it cannot be executed also. The decree, if it is passed, it can't be executed or satisfied. But I will point out, my lord, the nature of entire litigation is only boundary dispute. Unless there is a clarity, Your Honor, my lord, it is very difficult.
ಆಯ್ತು ಸರಿ ಮಾಡಿ.
At least ನಮ್ಗೆ ಏನಂದ್ರೆ ಅಲ್ಲಿ ಏನು ಮಾಡೋದು ಬೇಡ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
List the matter on 23rd.
ಆಗ್ಲಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿವರೆಗೆ ಸ್ವಾಮಿ ದಯಮಾಡಿ ತುಂಬಾ ತೊಂದರೆ
ಅಲ್ಲ ಈಗ.
ಅಲ್ಲ ಕಟ್ಟಡ ಕಟ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ.
List the matter on 23rd. Yes, next.
ಅಲ್ಲ ಮಿಲೋಡ್, ಅಟ್ ಲೀಸ್ಟ್ ಅಲ್ಲಿಂದ ತನಕ ದಯಮಾಡಿ ಅಲ್ಲ ಅಟ್ ಲೀಸ್ಟ್ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಆದ್ರೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ. ನನಗೆ
Pendency of this petition will not come in the way of the concerned court to consider the application filed by the third defendant on its merit.
My only submission is if defendant number 1 and 2 is not contesting the suit and they've compromised with me, he cannot have any objection, my lords. My matter can be disposed of insofar as his.
ಇದು ಡಿಸ್ಪೋಸ್ ಈಗ ಆಗಲ್ಲ ಬಿಡಿ. List on Friday. Yes.
Interim order may be extended.
Interim order subsisting will continue to the next date.
ಅಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಟು ಮಿಲೋಡ್ ಟ್ರಯಲ್ ಐ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್.
Nothing, ಏನು ಆರ್ಡರ್ ಇಲ್ಲ Friday. Yes.
ಅಲ್ಲ ಸ್ವಾಮಿ ದಯಮಾಡಿ
Friday.
ಅಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ ಅಟ್ ಲೀಸ್ಟ್ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್
3 ದಿವಸದಲ್ಲಿ ಏನ್ ಕಟ್ಬಿಡ.
ಮುಂದೆ ಇವಾಗ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಇವನ್ ಲಾಸ್ಟ್ ಫ್ರೈಡೆ ಬಂದಾಗ್ಲೂ ಕೂಡ ಅದೇ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಲ್ಲ ಅಟ್ ಲೀಸ್ಟ್ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಆದ್ರೂ ಕನ್ಸಿಡರ್.
ನೀವೇ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ
ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಏನಾಗಿದೆ
2004 ಅಲ್ಲಿ ನೀವೇ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಒಪ್ಕೊಂಡು.
ಟ್ರೂ ಮೈ ಲಾರ್ಡ್.
ಈಗ ನಿಮಗೆ ಒಂದ್ ನಿಮಿಷ ಯಾವ ಸೈಡ್ ಬೇಕು ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ತೊಂದರೆ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ದಯಮಾಡಿ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿನನ್ನ ಅವರು ಕಬಲ್ಸ್ಕೊಳ್ಳೋಕೋಸ್ಕರ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಈಗ 2004 ಅಲ್ಲಿ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡ್ ಆಗಿದೆ. ಆಮೇಲೆ 10 years ಮಿಲೋಡ್, ಆಫ್ಟರ್ 10 years
will consider that. Yes.
ಅಲ್ಲ ಮಿಲೋಡ್, ಅಟ್ ಲೀಸ್ಟ್ ಅವರ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇ ಬಿ ಕನ್ಸಿಡರ್.
On Friday we'll pass that order. Yes, next.
29.
My lord, in this case, my lord, civil case, commercial OS has got filed for a recovery of
the agreement. Why are you on VC?
My lord, I'm in the out of station, my lord. Hence, I am appearing through the VC.
So we'll send it out of station then. Yes.
No, my lord, here in this case, my lord, 2,20,000 has court fees has been filed, has been paid for the recovery of 58,70,000 arrears of rent, my lord. And after filing the return statement, they have the defendants even filed the return statement, my lord, all the defendants, and thereafter, my lord, they come up with a new, my lord.
Where is the agreement?
My lord, the agreement is not placed, my
ಅದಕ್ಕೆ
lord.
out of station ಅಂತ ಹೇಳಿದ್ದು. Yes, list after 2 weeks.
My lord, kindly,
ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು? Section 8 is allowed, all right?
Yes, my lord, but after filing of
Section 8
return
allow
statement,
ಮಾಡಬೇಕಾದ್ರೆ agreement ಎಲ್ಲಿದೆ? Where is the agreement? Without placing the agreement, you want an interim order. Yes, place the agreement and you are not in station. Yes.
Monday, my lord, kindly have it on Friday.
Yes, produce the agreement and then move the matter.
Yes.
Two rule to application.
ಇದು ಪಾಸ್ ಓವರ್.
ನಮ್ದು 31 ಅವ್ರ ಅಪಿಯರ್ ಆಗಿದ್ದಕ್ಕೋಸ್ಕರ ನಾನು
ಪಾಸ್ ಓವರ್ ಇದು ಮುಗಿಯಲ್ಲ ಇದು ಇಲ್ಲದೆ.
31.
Petitioner.
Naveed.
Lords, was the delay of Lords
1200 days in filing written statement condoned without anything.
Yes, Lords. Lords, any condition, Lords, permit me to Lords file written statement. Lords, I was unwell, Lords, I have produced a medical report.
Unwell, 3 ವರ್ಷ.
2016, Lords, I am Lords underwent Lords cardiac Lords.
So
Lords, I was admitted. Thereafter, Lords, my health was deteriorating, Lords, I could not able to file.
Now you are
but with any condition, Lords,
now you are in the pink of
Lords,
health.
I agree, Lords.
Yes.
Lords, I have no case, Lords.
You have no case?
But with some condition, Lords, permit me to file written statement.
But get the respondent. The petitioner is before this court calling in question an order which rejects an application of rejects the filing of the permission to file the written statement on the score that it has been it is sought to be filed after 1,126 days delay. The delay undoubtedly is inordinate. The application, the justification for delay is far from being satisfactory. But the learned counsel for the petitioner submits that he was unwell due to heart ailment, heart ailment. Therefore, the petitioner shall serve on the counsel who represents the plaintiff before the concerned court and file an acknowledgement of such service. List the matter on 23rd. Further proceedings before the concerned court till the said date shall remain stayed.
Plus two other petitions, my lords. The same has to be clubbed along with this.
Elladrallu delay na?
Plus, no, my lords. One is, my lords, one is filed for my lords to condone the delay, and another is for my lords to recall the order dated so and so, my lords.
Tag the petition along with so and so. List on 23rd. Yes, next.
Okay.
32.
RA ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಎಸ್ ಸಂದೇಶ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೇವೆ. To hear on maintainability.
Maintainability.
Regarding jurisdiction, my lord will get a page number.
What jurisdiction?
My lord, the reason is.
Office objection ಇದೆಯಾ?
My lord, page.
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ?
ಇಲ್ಲ, ಈ ಕೇಸ್ ಅಲ್ಲ.
RL ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? ಅಷ್ಟರಲ್ಲಿ ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್?
We have not full execution.
ಮತ್ತೆ what's the problem here?
Well, the problem here is at page number 47, simple case, my lord.
Correct, ಹೇಳಿ.
Page number 47, the respondent has filed a suit for partition. The value is 32,51,250. She claimed off share. But the trial court has granted 1/6 share. Value of 1/6 share is 5,41,875. They have filed the FDP also for the very same share. We have filed an RA before the appellate court challenging the decree passed in favor of the plaintiff. The appellate court has raised an objection.
With regard to court fee?
No, not regarding court fee, regarding jurisdiction. Court fee is fixed court fee for partition. Regarding jurisdiction, as per the valuation slip, value is more than.
ಅದು ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ ಈಗ?
ಹೌದು, ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್.
ಎಸ್ ಸಂದೇಶ್.
I have no case actually. The court has, office has failed to understand the court's concept. The jurisdiction point is concerned. Or the petition before the honorable court, it has to be allowed and RA has to be registered.
Restored. Yes, allowed.
Yes, please.
33.
Not in this case, suit for specific performance.
Stamp duty and agreement.
Please, ma'am. There are 3 scheduled properties, my lord, mentioned in the agreement. Only one property has been considered while passing the impugned order. May I take this honorable court?
Yes, respond.
Next year D.
Only one property has mentioned in the order sheet, my lord.
ಒಂದೇ
One property
ಒಂದು
was
ತಗೊಂಡಿದ್ದಾರೆ, ಅದು
mentioned.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ.
Calculation, ಅವರು entire property calculation
will
ಮಾಡಿದ್ದಾರೆ.
direct the court to reconsider.
Please.
The petitioner is before this court seeking the following prayer. The petitioner is plaintiff.
Plaintiff.
Prayer ಕೂಡ ಇರೋದು return of the amount ಅಂತ ಕೇಳ್ತಾರೆ.
The petitioner is the plaintiff, institutes a suit for
Specific performance.
specific performance.
Return of the amount of
The
A specific performance in OS 13 of 2024 for the return of the amount that was the subject matter of the agreement of sale. The respondent files his written statement. The concerned court passes an order directing the plaintiff herein to pay the deficit stamp duty and agreement of sale on sale dated 21/3/2023. The learned counsel for the petitioner and the respondent in unison would submit that the concerned court has erred in passing the impugned order, as the agreements, all the agreements of sale are not taken into consideration, and the calculation of court fee also is erroneous. The concerned court has ordered as follows. Page 32-33. The light of the said submission of the of both the learned counsel appearing for the petitioner and the respondents, the matter would require reconsideration at the hands of the concerned court. In that light, the petition stands, the petition is allowed, the so and so stands quashed, the matter is remitted back to the concerned court to pass orders afresh, taking into consideration all the agreements of sale and drawing appropriate stamp duty to be paid on those agreements, if any.
And also considering Article 2, 5E2 of the Stamp Act.
In accordance with law.
Please.
Yes. Ordered accordingly.
That's all.
The reason for the aforesaid reasons. Yes, next.
34.
This is suit for partition. my lord.
Correct, eucalyptus tree.
Sir, my lord.
Eucalyptus tree.
Yes, my lord. The plaintiff has filed a value of the trees are 9,20,000, my lord.
But
The
it is
defendant has filed
8
7
lakh,
lakhs.
ಎಷ್ಟು 7,10,000.
20,000.
ಈಗ ಏನ್ ಮಾಡೋಣ ಈಗ?
My lord, 2 ಲಕ್ಷ ಲಾಸ್ ಆಗುತ್ತೆ ಅನ್ನೋದು ಅಷ್ಟೇ ಅವರ ಕನ್ಸರ್ನ್ ಇಸ್.
ಸರಿ. You serve on the respondent.
Please, my lord.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. The issue is with regard to the value of the eucalyptus tree. The petitioner depicts the value to be 9,20,000 while the defendant at 7,10,000. Difference is 2,10,000, which will be due to which the petitioner would be put to a loss of the said amount. In that light, there shall be an interim order spread for list the matter on 23rd. We'll close it on that day. Get him.
Great.
Next.
35.
But plaintiff's petition, my lord.
At the learned counsel appearing for the petitioner. The concerned court, you are the plaintiff, right?
And the plaintiff, suit for
The
declaration.
petitioner is the plaintiff. Suit for?
Declaration and
Suit,
injunction.
suit for institute suit in OS 13 of 2024, declaration and injunction. The concerned court grants an grants temporary injunction, answering an application order 39 rule 1 and 2. This is called in question by the respondent defendants before the first appellate court, which has reversed the said finding. The learned counsel for the petitioner takes this court to the documents appended to the petition to demonstrate, prima facie that the trial court had appropriately granted temporary injunction. In that light, the order of the first appellate court shall remain stayed till the next date of hearing. Petitioner to serve on the counsels who represent the respondents defendants before the concerned court and file an acknowledgement of such service by the 18th. List the matter on 30th.
Grateful.
36.
What document you want to produce, sir?
So it's already there, so it's an IA document.
Yes, Ketan.
My lords, already has filed a application under order 8 rule 1A, my lord.
Correct.
To mark very same document.
What has happened to that?
That application has been dismissed. He has not challenged that order, my lords. Kindly turn page number.
What date is that order?
114, my lord, page number 2011-2024.
114.
Order dated 2011-2024, my lords.
One moment.
Operative portion at 117.
ನಿಶಾನೆಯಿಂದ ಗುರುತಿಸಲು ಬರುವುದಿಲ್ಲ ಎಂದು ಆದೇಶಿಸಿದೆ.
Now again he has filed application IA number 21.
ಇದು IA number?
ಇದು IA number 18, my lords.
18.
Yes.
Same relief?
In that 9 he has sought for the marking of 9 documents. One amount.
One of the document was this?
Yes.
Which is this document now?
Partition deed dated 14/11/1990, my lord.
Where is the documents that are permitted there?
Lordship, this is an unregistered document.
Correct. ಮುಂಚೆ ಮಾಡಿದ್ರೆ
ಮಾಡಿದ್ದು ಹಳೆ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇತ್ತು. Next, if you see, what we furnished was a certified copy.
Unregistered sale deed.
Partition.
If you see the order 115 ಅಲ್ಲೇ ಹೇಳಿದೆ, it is a certified copy.
Order 8 rule 1 ಅಲ್ಲಿ ಒಂದು ಹಾಕಿದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್. ಅದು ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿ?
Order sheet al mention ಇದೆ. IA not produced, my lords.
I want to see whether ಎಲ್ಲಿ the order sheet al mention.
Page number 111, my lords. Typed copy is that. 201. Typed copy is that.
Where is the application that he filed? Order 8 rule 1 application ಎಲ್ಲಿದೆ ಹಳೇದು?
Sir, Orders are produced, applications.
Where is the application? What all documents did you seek to produce?
We sought documents including this, about 9 applications, copy
Huh.
of which is not there in this docket.
9 items.
One of this is
One
this.
of them is this. That is rejected.
That is rejected.
Why you did not challenge that?
No, what was certified copy is Swamigale, ivaga original sikkide.
Oh, certified copy reject.
Reject ಮಾಡಿದ್ದಾರೆ.
Where is the reason for rejection?
The reason for rejection next idalide, it
Yeah.
was
Page. ಪಾಲು ವಿಭಾಗದ ಪ್ರತಿಯನ್ನು ನೋಡಲು ಬರುವುದಿಲ್ಲವೆಂದು
ದಾಕ್ಷಿಣ್ಯ ಮೌಲ್ಯ ಇರುವುದಿಲ್ಲ.
ನಕಲನ್ನು ಈಗ ನಿಶಾನೆ ಎಂದು ಗುರುತಿಸಲು ಬರುವುದಿಲ್ಲ ಎಂದು ತಮ್ಮ ವಾದವನ್ನು ಮಂಡಿಸೋ. ಈಗ ಒರಿಜಿನಲ್ ಇದೆಯಲ್ಲ?
Earlier out kindly.
ನಕಲು ಅಂತಿದೆ ಇಲ್ಲಿ.
ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ನಕಲು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಂತಿದೆ ಇಲ್ಲಿ.
Finding is that I may be permitted to read, my lords. ಮೂಲ ದಾಖಲೆ ನೋಂದಣಿಯಾಗದೆ ಇರುವ ಕಾರಣ ಅದಕ್ಕೆ ಯಾವುದೇ ಸಾಕ್ಷ್ಯ ಮೌಲ್ಯ ಇಲ್ಲದ ಕಾರಣ ಅದರ ಅಧಿಕೃತ ದೃಢೀಕೃತ ನಕಲಿಗೂ ಯಾವುದೇ ಸಾಕ್ಷ್ಯ ಮೌಲ್ಯ ಇರುವುದಿಲ್ಲ ಕಾರಣ
ಅದು ಕೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡ್ಲಿ ಅದನ್ನ.
My lords,
ವಿತೌಟ್ ಬಿಫೋರ್ ದಟ್ ವಾಟ್ ಇಸ್ ದಟ್?
my lords, same document
Partition and register ಆಗಬೇಕು ಅಂತ.
For a minute, my lords. Same document has been produced by the different number 2 in this suit, my lord, produced in OS number 308 of 1993.
408.
Yes, houdu. Kindly
308 ಅಲ್ಲ 408.
408 of 1993. Kindly see the findings of given by the trial court.
That suit is pending.
ಇಲ್ಲ ಅದು ಡಿಸ್ಪೋಸ್
ಆಗಿದೆ
ಆಗಿದೆ.
sir.
ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇಟ್ಸ್ ಇರ್ರೆಗ್ಯುಲರ್ ಡಾಕ್ಯುಮೆಂಟ್ cannot be looked into ಅಂತ ಆ ಸೂಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ. For a minute, my lords, page number 255. In that suit, my lords, a very specific issue has been framed in this document.
Then we'll hear it.
Please, my lord.
We'll state.
My lords.
Yes. There is nothing wrong in producing the document.
2-3 citations ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿಗಳೇ.
My lord,
ಪರವಾಗಿಲ್ಲ.
my lord, in this regard, my lord, I am relying on.
Oh, ಕೊಡಿ sir. ಎಲ್ಲ we'll look into everything. Lest the matter on 30th, as the matter would require consideration. Interim, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing.
Please, my lord.
Next. ಎಲ್ಲ ಇಬ್ಬರದು ಕೊಡಿ. 30th ಬೇಡ, 28th ಹಾಕಿ ಮಾಡಿ.
Citations have already
28,
given in the
alright.
previous bench.
28th, yes.
Senior counsel is not.
No, senior counsel, surface proceedings na converted here.
Kindly be next week.
No, not maintainable at all before the concerned court.
Kindly be on Monday.
It's a surface recovery proceedings you have sought for staying everything, yes.
Maybe on Monday. Kindly be.
The petitioner is before this court calling in question an order. What order are you challenging? Order passed on applications IA 1 and 2 of 2025 seeking stay of all recovery to be instituted, recovery against the petitioners by the asset reconstruction company. A pure and simple surface proceedings are projected before the concerned court. The civil suit so far instituted by the petitioner is not even maintainable. The learned counsel for the petitioner seeks time on the score that the arguing counsel has some inconvenience today. List the matter day after tomorrow. It is made clear no further adjournment would be granted in the matter on whatsoever ground. Friday, Hakiman. Friday, not day after tomorrow, Friday.
38.
I'm the petitioner, my lord. I'm challenging the annexure.
Which document you wanted to mark, sir?
It's a photocopy of the unregistered partition deed dated 15th July 1985, my lord.
Correctly rejected.
Nowhere acted upon 40 years.
Is allowed?
Yeah, it is allowed, my lord. And all the
Stood for.
Declaration.
Now defendants have produced that.
Yeah, my lord.
Yeah.
It is nowhere acted.
Yes.
Upon 40 years. Now they have come up with a.
Petitioner is the plaintiff. Is before this court calling in question an order dated 7/3/2025 passed in OS 1431 of 2020 allowing an application in IA 5 filed by the defendants seeking to produce an unregistered partition can be a partition deed of the year 1985, which had not seen the light of the day for the last 40 years. In that light, till the appearance of the respondents, there shall be an interim order of stay of further proceedings before the concerned court. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings. Next.
39.
So appearing for the petitioner.
Will not, everybody stay over.
May I please, Bala?
ಯಾವ್ದು seal number?
39. 39.
For petitioner, my lord, respectfully pray this honorable court may please to expedite the disposal.
Expedite disposal of what, sir?
Petition, my lord.
Petition na? ಯಾವ ವರ್ಷದ petition, sir? ಯಾವ ವರ್ಷದ suit, sir? 2023 suit ಗೆ expedition ಎಲ್ಲಿದೆ? Caution ಕೇಳಿದ್ದೀರಾ? That's not your prayer.
ಕಾಶಿ ಕೇಳಿದೀವಿ
ಮತ್ತೆ 2023 suit ಅಲ್ಲಿ anything else?
Nothing.
The petitioner, though sought quashment of the orders passed by both the trial court and the first appellate court, would seek to restrict his prayer for a direction for expeditious disposal of this suit. The suit is of the year 2023 and for injunction against the respondent. Injunction against the petitioners instituted by the respondent. In the light of the said prayer and the suit being of the year 2023, the concerned court shall endeavor to expeditiously dispose the suit with the aforesaid observation without interfering with the impugned orders. The petition stands disposed. Next.
40.
Hearing for the petitioner, Your Lordship. The suit is for one for partition
ಆಯ್ತು,
declaration.
not to alienate ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes,
ಏನೀಗ?
Your Lordship. Because we are asking that respondent.
You want to
defendant
alienate
and
immediately?
No, no, my lordship.
Suit is for partition.
Suit is for partition. We have
Yes.
filed a suit. We are asking the respondent number 13 to 19 not to alienate because they are also claiming title or the property along in view of the sale deed.
Why they are going to alienate, is it?
They have not alienated, my lordship.
How?
No, my case is.
Correct, ನೀವೇ plaintiff.
Yes, my lordship.
Order 39(1) and 2 is not granted. I am asking what is your apprehension?
Because, my lordship, there is a writ petition filed by them, WP 3372 for 2024, which was where an order was passed by the deputy commissioner, setting aside the order of assistant commissioner.
What
Where
was
the
that?
assistant commissioner has ordered for entering their names in the revenue records. They have challenged before this honorable court, and the honorable high court has set aside the order of assistant commissioner,
Defendants.
deputy commissioner, and they have remanded the matter back to the assistant commissioner for entering their name. Now, on the basis of that order, they can get their name
Petitioner
entered.
to serve on the defendants. Represent ಆಗಿದಾರ ಅಲ್ಲಿ?
No, madam. ಅಲ್ಲಿ
The petitioner
ಅಲ್ಲಿ
to
ಆಗಿಲ್ಲ.
serve on the defend ಆಗಿದಾರ?
ಇಲ್ಲ ಅಲ್ಲಿ
Defendants
date ಕೊಟ್ಟಿದ್ದಾರೆ.
by way of hand summons and file an acknowledgement of such service by the next date list on 30th. The defendants and in the meantime shall not alienate the property.
God bless.
Yes, next.
41.
ಯಾರು plaintiff?
ನಾವೇ ಸರ್, give it.
BDM ಎಲ್ಲ?
BDM.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Suit for declaration.
What declaration?
Declare that we are the owner of the property.
Acquisition.
Yes, my lord. This is the allotment property made in favor of one Shankarappa. Thereafter, he sold the property to.
How is the suit maintainable?
My lord, the citation.
What citation?
Division bench judgment we have relied before the honorable court. My lord, mainly.
How is the suit maintainable? Writ petition ಹಾಕ್ಬೇಕು. ಕೊಡಿ. Yes, Ajay Kumar.
We had taken up the plea, my lords. The matter has to be referred to the special court under land grabbing.
Land grabbing.
Out. Lords, there's one more writ petition also. Lords, we had sought, my lords, for.
ಅಲ್ಲಿಗೆ ಕಳಿಸ್ಬಿಡೋಣ.
My lord, 29 may kindly be produced for a moment. Division bench judgment. Para 29 may kindly be produced. I will read. Thus necessarily, if a person is claiming a right by way of lawful entitlement through any valid document issued or granted in favor of such person, which though disputed by the authorities, concerned on the ground that such a grant allotment or the like could not have been made in
ಈಗ
favor of
ಏನ್
such
ಕೇಳಿದಿರಾ ನೀವು?
we are here for the declaration on the basis that BD itself sold the property. BD allotted the property to
ನಿಮಗೆ?
my vendor. My vendor.
To your vendor.
Yes.
When was that?
89 to
19?
89,
When did you purchase the property?
1991.
1991.
Yes, madam.
ಈಗೇನಾಗಿದೆ ಪ್ರಾಬ್ಲಮ್?
There afterwards, we have filed the two suits for injunction that is also decreed by the honorable trial
That
court.
BDA was a party there?
BDA was the party
ಆಮೇಲೆ?
and no RFA was preferred, no stay was granted.
ಆಮೇಲೆ?
There afterwards interference again started and this is the suit seeking for the declaration is pending. At the stage of cross of PW1, they have come up with the one more application under section 20 of the Karnataka Land Grabbing Court Act. And all these cases were alert, my lord, until the court has come to the conclusion that this document is forged, the court
Yes,
cannot send
Ajay
the-
Kumar.
What had to be decided itself is whether there is a question of land grabbing or not. My lords, the land grabbing special enactment is made for that very purpose. And my lords, the act also makes it quite clear, my lords, that the special court would be exercising the powers of the civil court itself. Section 10, my lords, of the Karnataka Land Grabbing Prohibition Act. My lords, may I just read that.
Odi.
Save as expressly provided in this act, the provisions of the Code of Civil Procedure and Code of Criminal Procedure, insofar as they are not inconsistent with the provisions of this act, shall apply to the proceedings before the special court. And for the purposes of the provisions of the said enactment, special court shall be deemed to be a civil court, or as the case may be, a court of sessions, and shall have all the powers of a civil court and a court of sessions, and a person conducting a prosecution before the special court shall be deemed a public prosecutor. Insofar as the criminal aspect is concerned, so far as civil aspect is concerned, it will be a trial of a suit itself. My lords, what the trial court now has said, my lords, as per the interim order, my lords, firstly, my lords, we prayed that after the filing of the written statement, please frame it as a preliminary issue to decide on the maintainability.
Jurisdiction.
Please, my lords. The court says, my lords, at this stage, I can't do it without a trial. My lords, we file an application at least so that the matter could be transferred to the special court and the provisions of the act. That also has been rejected, my lords. There is one more connected writ petition which is there. Writ petition number 10765/2025.
Tag this petition along with WP. ಅದು ನಿಮ್ದೇನಾ ಮಂಜುನಾಥ್? ಅಲ್ಲ ಅದು ನೀವು
Learned friend appears there also.
between the same parties.
Please.
Tag this petition along with so and so. List tomorrow.
Right.
42.
I appear for the petition. Application order 1 rule 10(2) rejected. I am a
Who are you?
I'm an employee. Suit is for recovery of money.
For the recovery of money.
Against defendant number 1, which is a company. The allegation is I inform them that they have to make payment of the entire amount of money before goods are supplied. That's the only allegation against me.
All right.
Therefore, my lord, I can't be a party to the proceeding.
It's
The
allowed, is
plaintiff
it?
has made me a party.
It's allowed
I am a
now?
defendant.
No, it's allowed now.
It's no. The application, lord, is dismissed. I made an application to delete me.
Deletion.
Deletion.
There. Yes.
Page 226, my lord, is my application.
Where is the
The plaint, my lord.
observation?
Can I request, my lord, kindly see the plaint?
No, order bunny.
Yes. Order actually records something completely wrong. Order records me as a director.
That's what. Yes.
Please see para 12 at page 57.
You're an employee and ಎಲ್ಲಿದೆ?
It says common version. Please see para 12. Common version of defend 2 and 3 is that
So
they are
you show
directors.
me one thing. You're
Yes,
an
madam.
employee and ತೋರಿಸಿ sir.
Yes. My application, lord, is at page number 215.
Page number?
215. Please see, my lord, at page 218, para 4, last line. I state that I am presently working as sales support manager, defend number 1, and was previously working as order processing and export administrator during the period of alleged transaction. I state
Sales support manager, order processing and export administrator.
I said plaintiff erroneously stated my designation as director of the defend number 1. The suit also is not for joint and several liability.
Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner. The petitioner files an application under Order 1 Rule 10(2) seeking deletion from the array of defendants before the concerned court in OS 177 of 2023. The plea of the petitioner is that he or she, she has been erroneously described as a director in the cost title in the plaint. The learned counsel would take this court through documents appended to the petition to demonstrate, albeit prima facie, that the petitioner is an administrator, the
Order processing and export administrator.
order processing and export administrator and an employee. In the light of the said submission, the order dated so and so, the
Proceedings against
proceedings in so and so commercial, is commercial alla?
commercial lawyers.
Which is that? 177 adena?
Yes, commercial lawyers 177.
Commercial laws 177 of 2023 shall remain stayed till the next date of hearing. Petitioner to serve on the counsel representing the plaintiff and the other defendants before the concerned court by the 11th
Yes, will serve the night.
and file an acknowledgement, list the matter on 30th.
Great.
Yes, next.
43.
My lord, I am for the petitioner.
ಯಾಕೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ?
My lord, without issuing a liberty, my lord, the order has been passed. Page number 95, my lord. My lord, I filed a memo.
Why did you want to withdraw the suit?
My lord,
At what stage you want to withdraw the suit?
initial stage, my lord. Before issuing a notice, my lord, I filed a memo. But inadvertently filed a commercial OS before the civil court, my lord.
All right.
The civil court has posted the matter for maintainability, my lord. At that time, my lord, I filed a memo for withdrawal to seek liberty.
ಲಿಬರ್ಟಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ?
That's what.
The petitioner is before this court calling in question an order dated 22/2/2025 by which the commercial OS 7 of 2025 is though permitted to be withdrawn on a memo filed by the petitioner, but liberty to file a fresh suit on the cause of action has been denied. The learned counsel for the petitioner takes this court through the order sheet maintained before the concerned court to demonstrate that when the issue of maintainability before the commercial court cropped up, the petitioner filed a memo at the initial stage itself seeking to withdraw the suit and present it before the concerned court as it was the issue of jurisdiction. The memo is answered partially by permitting withdrawal, but does not grant the liberty that the petitioner at all times did have in law to file a fresh suit In that light, the order runs counter to law and is to be necessarily obliterated. So it's allowed quashed the liberty, quashed insofar as it denies liberty. Petitioner is at liberty to institute a fresh suit if available in law. Yes. Ordered accordingly.
44.
Happy for the petitioner.
Well, firstly, my lord, entire writ petition copy is not served.
I'll survey copy.
As per the order passed by December.
ಆಯ್ತು ಎರಡನೇದೇನು?
Second, my lord, the trial court, my lord, passed my lord order in the form of my lord second preliminary degree. Such being the case, they have to file appeal against this order.
ಏನು ಆರ್ಡರ್ ಇದು?
ಇದರಲ್ಲಿ redetermination of my lord shares.
FDP ಅಲ್ಲ?
FDP redetermination of shares. ಯಾಕೆಂತಂದ್ರೆ
IML FDP ಕಂಪ್ಲೀಟ್ ಆಗಿರೋ ಪರವಾಗಿಲ್ಲ, ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಅಲ್ಲ. Reallotment of shares on the basis of LR application.
Reallotment of shares would be tinkering with the preliminary decree.
ಅಲ್ಲ, there are two persons have been combined in past
genealogical tree, my lord, may permitted to do genealogical tree. ಏನಕ್ಕೆ ಈ ಪುನಃ ಇನ್ನೊಂದ್ಸಲ re-adjudication ಆಯ್ತು?
They do not belong to the family? ಮತ್ತೆ
ಇದು
will ಮೇಲೆ
petitioner is not belong to family.
ಅದನ್ನೇ ಕೇಳಿದ್ನ.
ಅಲ್ಲ, will ಮೇಲೆ
She was not belong to
will not proved ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಇದು ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಏನಾಯ್ತು?
Not a party in the preliminary decree?
Yes.
ಇರಲಿಲ್ಲ, ಅವಾಗ ಇರಲಿಲ್ಲ. ಇಲ್ಲಿ FTP ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಬಂದಿದ್ದವರು.
On the basis of a will, is it?
Will ಇಲ್ಲ.
One submission, she was already R8.
Separate suit.
ಅಲ್ಲ, she was already R8 in the preliminary decree. Your lordship, kindly turn down to page number.
If you are springing into action in the FDP on the basis of a will that was in subsistence even at the time of preliminary decree. Yes.
ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇದ್ರೆ ಒಂದು ನಿಮಿಷ ನಾವು ಅಂತ ತಪ್ಪಾಗ್ಬಿಟ್ಟು
ನೋಡ್ಬಿಡಿ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಸೂಟಲ್ ಪಾರ್ಟಿ ಇದ್ರಾ?
ಇಲ್ಲ, ನೋಡ್ತಾ ಇಲ್ಲ.
R8.
ಚಿಕ್ಕ ಹೊನ್ನಮ್ಮ ಇಲ್ಲ.
ಇಲ್ವಾ?
Dependency of the suit, FDP or ಯಾರು ಅವರಲ್ಲ ಇವ್ರು ರೂಪ.
FDP ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ ಬರ್ತಾರೆ ಬರ್ಲಿ. ಅಸ್ಯೂಮಿಂಗ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ರೂನು ಕೂಡ ಇದು this is just like a second preliminary decree which they have to challenge in RA. First, second thing is though they have produced will.
No, ಏನ್ 2197 ಹಾಕಿದ್ದ?
No, your lordship.
ಅಪ್ಲಿಕೇಶನ್ ಏನ್ ಹಾಕಿದ್ರು?
Application impleading application.
No, she was R8 and then she was made as R1A because of the application, LR application. Twice she was added.
Already R8 ಇದ್ರ?
FDP ಅಲ್ಲಿ ಇದಾರೆ.
ಅಲ್ಲ ಸೂಟ್
At
ಅಲ್ಲಿ
page number 40.
ಸೂಟ್ ಅಲ್ಲಿ ಇಲ್ದೇ ಇರೋದು FDP
ಇಲ್ಲ. FDP ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಬರ್ತಾರೆ ಅಲ್ಲೂ ಆಗುತ್ತೆ.
ಇದು reallocation of shares ತಿರ್ಗಾ ಒಂದ್ಸಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ R1A ಅಂತ. Twice she has made us party in the FDP proceedings. R8 page number 40.
FDP ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಫಸ್ಟ್ ಹೇಳಿ?
FDP ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಬಂದಿದ್ದು ಅದನ್ನೇ.
ಅವರಲ್ಲ ನೀವೇ ಮಾಡಿದೀರಾ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
FDP ಅಲ್ಲಿ R8 ಅಲ್ಲಿ ಇದೆ. Order ಅಲ್ಲಿ R8 ಇದೆ.
ಆಯ್ತು ಅವ್ರು ಪೂರ್ತಿ ಕಾಪಿ ಕೊಡಿ. Give the entire copy.
And then, my lord, another submission. Court has allotted, my lord, by seeing the, my lord, I have produced already genealogical tree. ಇವ್ರಿಗೂ will ನ disbelieve ಮಾಡಿದ್ರು ಕೂಡ 1/5 ಶೇರ್ ನೇ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರದ್ದೇನು ಅವ್ರ ಶೇರ್ ನ ನಮ್ಗೇನು ಅಲಾಟ್ ಮಾಡಿಲ್ಲ. So, my lord, staying this order, my lord, only, my lord, to prejudice me.
ಅಲ್ಲ only in so far as the share is concerned will do.
ಅಂತ ಮಾಡ್ತಾರೆ.
ಇನ್ನೊಬ್ರು ಶೇರ್
ಅವ್ರ ಶೇರ್ ಅಂತ ಮಾಡಿ
ಇಶ್ಯೂಸ್ ಇಲ್ಲ ಅವ್ರು ಬರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ನಿಮ್ ಶೇರ್ ಎಷ್ಟು ಸರ್?
ನಂದು ಶೇರ್ ಇದೆ. ನನ್ನ ಶೇರ್ ಜೊತೆಗೆ ಇನ್ನೊಂದು ಶೇರ್ ವಿಲ್ ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಇದೆ.
ಸೆಕೆಂಡ್
ಶೇರ್ ಇಲ್ಲ. ಅವ್ರ ಶೇರ್ ಇಲ್ಲ. ಅವ್ರ ಶೇರ್
ನನಗೆ ವಿಲ್ ಮೇಲೆ ನಾನು ಕ್ಲೇಮ್ ಮಾಡಿದ್ದು ಇನ್ನೊಂದು ಶೇರ್. ಸೊ ಅದನ್ನ ಡಿನೈ ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ ಶೇರ್ ಏನಿದೆ ಅದನ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದಾಯ್ತು ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Whatever your share is concerned will protect it. ಅವ್ರಿಗೆ ಯಾಕೆ ಮತ್ತೆ
ಇಲ್ಲ ಅವ್ರಿಗೆಲ್ಲ 1/5 ನಾನು ವಿಲ್ಲಲ್ಲೂ ಬಂದಿತ್ತು, 2 ವಿಲ್ ಬಂದಿತ್ತು, ಒಂದು ವಿಲ್ ನ ಅಲೋ ಮಾಡಿ ಇನ್ನೊಂದು ನನ್ನ ವಿಲ್ ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
ಇನ್ನೊಂದು ವಿಲ್ ಏನಾಗಿದೆ?
ಅದು ಎರಡು ವಿಲ್
ಅಲ್ಲ ಇನ್ನೊಂದು ವಿಲ್ ಯಾವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
ನಾನಲ್ಲ, ಇನ್ನೊಬ್ರು ಡಿಫೆಂಡೆಂಟ್ ಸತ್ತಾಗ, ಇನ್ನೊಬ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸತ್ತಾಗ ಇನ್ನೊಬ್ರು ಬಂದಿದ್ದಾರೆ.
ನೀವೇ ನೀವು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಡೀಟೇಲ್ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ದಾರೆ.
List the matter on Friday.
1/6 ಗೆ
ಪೂರ್ತಿ
ಕಾಪಿ ಕೊಡಿ.
ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಬೇಕು ಎಕ್ಸ್ಟೆಂಡೆಡ್.
List the matter on Friday. Friday ವರೆಗೆ ಮಾತ್ರ. We'll close it on Friday.
ಅಲ್ಲ ಉಳಿದ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಬಹುದು. ಉಳಿದವರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಇಬ್ಬರ ಕಂಟೆಸ್ಟ್ ಇದೆ.
ಅಲ್ಲ ಉಳಿದವರ ಶೇರ್ ಎಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಬೇಡ. ಎಸ್ ಮೆಮೊ ಕೊಡಿ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೊ ಕೊಡಿ. ಕೊಟ್ಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಮೆಮೊ
ಅವ್ರ ಇಂಟ್ರೆಸ್ಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವರು ಸೂಟ್ ಹಾಕೊಂಡು ಬರ್ಲೂಬಹುದು, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
ಎಸ್
45.
ರೆಸ್ಪಾಂಡೆಂಟ್
ಇರದೇ ಅದು ಅದ್ರಲ್ಲೇ ಬರುತ್ತೆ. ವಾಟ್ಸ್ ರಾಂಗ್ ಸರ್? Production of document ಅಲ್ಲಿ.
The document now I have sought for to produce by the defendant is, they have referred in the written statement. And in the deposition also he has admitted that it is in his custody. It is in the locker of the defendant DW1. He didn't produce.
Where is it? Come to page 14 and 15.
My lord, we have stated, my lord, it is not, my lord, in our
The
custody.
father of the plaintiff number 2 has not executed any agreement in
ಅವ್ರ
favor of
ಹತ್ರ
the.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರು ಇದೆ ಅಂತ ಎಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ?
Your lordship kindly peruse the affidavit filed by them before the court below and as well as the deposition in the cross examination.
ಅದು ತೋರಿಸಿ ಸರ್.
57, your lordship kindly come to page number 57. 57 ಆ ಮುಕ್ತಾಯರ ನಾಮೆಯನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇದೆಯೇ ಎಂದು ಕೇಳಿದಾಗ
ಯಾವ್ದು ಎಲ್ಲಿ 57 ಅಲ್ಲಿ
57 page
I am there.
top of the typed
ಗೋವಿಂದಪ್ಪ ಮತ್ತು ನಾಗರಾಜ್ ಅದ
page number 13 cross examination
58.
I'm sorry. ಆ ಮುಕ್ತಾಯರ ನಾಮೆಯನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇದೆಯೇ ಅಂತ ಕೇಳಿದಾಗ ಸಾಕ್ಷಿಯು ನಾನು ತಪ್ಪಿ GPA ಎಂದು ಹೇಳಿದ್ದೆ, ಅದು ಕರಾರು ಪತ್ರವಾಗಿದ್ದೆ ಕರಾರು ಪತ್ರವಾಗಿರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಆ ಕರಾರು ಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಲು ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಇರುವುದಿಲ್ಲ.
ಇದು ಯಾವ ಕರಾರು? ಅಗ್ರಿಮೆಂಟ್.
That is the agreement now sought to be produced before this at page number 58.
ಯಾವ ಇಸವಿಯಲ್ಲಿ ಮತ್ತು ಯಾವಾಗ ಕರಾರು ಪತ್ರವನ್ನು ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಎಷ್ಟು ಪ್ರತಿಫಲದ ಮೇಲೆ ಅವರಿಬ್ಬರ ನಡುವೆ ಕರಾರು ಪತ್ರ ಆಗಿರುತ್ತೆ ಎಂದು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ನಾನು ಈ ಕರಾರು ಪತ್ರ ನೋಡಿರುವುದಿಲ್ಲ.
1995
ನೋಡಿಲ್ದೆ ಇರೋದನ್ನ ಹೆಂಗ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ?
No, it is in their custody. That your lordship kindly come to page number 58. Further
Why this
cross-examination.
contradictory statements?
He has admitted.
Produce ಮಾಡಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, but ನೋಡಿರೋದಿಲ್ಲ.
ಅಲ್ಲ ನೋಡಿಲ್ಲ ಅಲ್ಲಿ, ಮಲರ್ 1995, subsequently ಮಲರ್ GPA was there. On the basis of the GPA, sale deed has been executed. Now suit is for declaration saying that the GPA and sale deed is not binding. Now my lord, as far as those documents, my lord, have been produced.
You are the plaintiff.
I am the plaintiff before the court.
Prove it, sir.
My lord.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡು ನಿಮ್ಗೇನ್ ಆಗ್ಬೇಕಾಗಿತ್ತು? ಮಾತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ರೂವ್ ಮಾಡಿ.
They says that my father has executed the document.
ಏನಿಲ್ಲ, 2016 ಸೂಟ್ ಅಲ್ಲಿ 25 on the application.
Judgment ಇದೆ.
My lord, this is not that I have tried to seek the document to be produced before the court below at the first instance. When they have referred in the written statement, they have not produced those documents.
Where is the reference in the written statement?
Written statement, your lordship kindly peruse the written statement filed by them.
Why do you take this contradictory stance?
My lord, in the cross examination, my lord, what he has said is, it might be in the office, we will check ಅಂತ ಹೇಳಿದ್ರು.
ಚೆಕ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಮೇರಲ್ಲಿ ಇರ್ಬೋದು ಅಂತ ಹೇಳಿದ್ರು.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
Page number 32, my lord. First document that they have referred is GPA dated 6/1/1994, registered as document number so and so.
It is not none.
And said.
ಯಾವ್ದು ಎಲ್ಲಿ ವಿಜಯ್ ಕುಮಾರ್ ಯಾವ್ದು?
Lordship, para number 13, ಅದರಲ್ಲಿ column wise they have mentioned serial number 1.
Para 13.
Para 13 of the written statement, my lord. The first document they are relying upon is the GPA dated 6/1/1994. In the cross examination, they says that it is not GPA, it is an agreement.
No,
I
GPA
wrongly stated as
GPA
they says that in the class
produce. He is
GPA
not asking GPA.
Sale agreement. We have not stated about.
His cases are on the basis
on the
of
basis
GPA.
of the agreement. Once
Not agreement, specific performance.
No,
Illa
madam.
declaration.
Declaration. They say that I have executed agreement in favor of defendant number 3. In turn, defendant number 3 has executed agreement in favor of the defendant number 1. Agreement ಮೇಲೆ agreement ಆಗಿ they have got a sale deed executed
Then
in their
agreement
favor.
ಮೇಲೆ agreement, disagreement ಆಗದೇ ಇಲ್ಲ.
Agreement ಮೇಲೆ agreement ಅಲ್ಲ. He was a confirming party.
Who?
My lord, defendant number 3, they, my lord, his father, my lord, enters into an agreement with defendant number 3. Subsequently, my lord, defendant, father of the petitioner and defendant number 3, my lord, entered into the agreement.
ಈಗ where is the plaint?
Client is at page number 17, my lord.
Interrogation, Lord. Yes.
Page 17.
Page 17.
ಹೇಳಿ.
The suit is for declaration and injunction filed by the plaintiff herein.
Where is the
Para
plaint?
number.
Where is the plaint, sir?
Page number 17.
Plaint ಅಲ್ಲಿ agreement ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದೀರಾ?
They says that
ಅವ್ರು ಸೇ ಬಿಡಿ, ನಿಮ್ ಸೇ ಹೇಳಿ. Plaint ಅಲ್ಲಿ agreement ಬಗ್ಗೆ ಹೇಳಿದೀರಾ?
we have not executed
Then you are not executed ಅಲ್ಲ. Now you are claiming that agreement to be produced. Have you said anything about the agreement there? Because you said
I have mentioned in my plaint that
ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು ಎಲ್ಲಿದೆ?
para number 12 of the plaint, my lord. They says that it is a GPA 6/1/1995, my lord.
Correct.
The plaintiff
6/1/1995
submits
was
that
shocked to
immediately.
see in collision of defendant number 3 relative plaintiffs in ಈ GPA ಮೇಲೆ ತಾನೇ ನೀವು ಕೇಸ್ ಹಾಕಿರೋದು ಈಗ?
ಈ GPA ಮೇಲೆ they got executed sale deed in favor of the defendant number 1.
Which agreement are you talking of now?
We don't know about the agreement. They says that in the written statement there is an agreement. It has been admitted in the cross examination that before executing the register.
Illa, we do not have, my lord. Now that their own case is, my lord, their case is, my lord, your lordship may kindly see the prayer. The prayer is, my lord, for
Then let
declaration.
court pass appropriate orders while molding the relief or
My
whatever.
lord, it is, my lord, for the court to decide, my lord, because now if you do not have the agreement, we cannot be directed. That is what the court says, my lord, in the.
No, correct. ಇಲ್ಲ ಅಂದ್ರೆ direct ಮಾಡಕ್ ಆಗಲ್ಲ.
There is no.
Page
not
number 56,
1995.
my lord, cross examination portion. He has categorically admitted before the court below that there is an agreement.
ಇರಬಹುದು ಅಂತ. ಆಮೇಲೆ ನೋಡಿಲ್ಲ ಎಲ್ಲ ಹೇಳ್ತಾರೆ.
No, he says that ನಾನು ಕ್ರಯಪತ್ರದ ದಿನಾಂಕ ನೆನಪಿಲ್ಲವೆಂದು ಹಿಂದೆ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಹೇಳಿದ್ದು ಆ ಕ್ರಯಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಇರುವುದಿಲ್ಲ. And he says in the next page, ಆ ಮುಕ್ತಾಯನಾಮೆಯನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇದೆಯೇ ಎಂದು ಕೇಳಿದ್ರೆ even power of attorney he can produce the document. That is also not produced before the court below.
ಯಾಕೆ GPA ಇದೆಯಲ್ಲ?
I have produced the.
You have produced whatever you have want to
My lord,
produce.
it is a certified copy that I have produced.
You can't build your case on the written statements.
No, my lord, I am not building the case on the basis of the written statement defense taken by them. It is on the basis of the. Your Lordship, kindly come to page number 59 of cross-examination portion. ಆ ಕರಾರು ಪತ್ರಕ್ಕೆ ಯಾರೆಲ್ಲ ಸಾಕ್ಷಿದಾರರು ಸಹಿ ಮಾಡಿದ್ದಾರೆ ಎಂದರು ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಈ ಕರಾರ ಪತ್ರವನ್ನು ಆಗುವ ಸಂದರ್ಭದಲ್ಲಿ ಯಾರ್ಯಾರು ಇದ್ದರು ಎಂದರು ನನಗೆ ಈಗ ಗೊತ್ತಿಲ್ಲ. ಆ ಕರಾರ ಪತ್ರವನ್ನು ಕಂಪನಿಯವರು ಮತ್ತು ಬಿ ನಾಗರಾಜ್ ರವರು ಸೃಷ್ಟಿ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ D1 ರಲ್ಲಿ ತೋರಿಸಿರುವಂತಹ ನಾಗರಾಜು ಬಿ ರವರು ಮತ್ತು ಮೂರನೇ ಪ್ರತಿವಾದಿ ಬಿ ನಾಗರಾಜ್ ರವರು ಬೇರೆ ಬೇರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಬಿ ಎನ್ ನಾಗರಾಜು ರವರು
Anything else?
It has been admitted in the cross examination.
No, sir. Yes.
Lordship, the last portion of the cross examination. ನಾನು ವಾದಿಗಳಿಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಮತ್ತು ದಾವಾ ಆಸ್ತಿಗಳನ್ನು ಲಪಟಾಯಿಸುವ ನಾನು ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹಾಜರುಪಡಿಸಿರಬಲ್ಲೆ ಎಂದು ಹೇಳಿರುವ ದಾಖಲೆಗಳನ್ನು ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದರೂ ಇಲ್ಲದಿರುವ ಕಾರಣ ದಾಖಲೆಗಳನ್ನು ಪಡಿಸುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗೋವಿಂದಪ್ಪನವರಿಗೆ ದಾವಾ ಆಸ್ತಿ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿ ಎಂದರೆ ಸರಿ. ಅವರಿಗೆ ವಾದಿ ಒಬ್ಬರೇ ಮಗಳು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ವಾರಸುದಾರರು ಯಾರು ನಾನು ವಿಚಾರಿಸಿ.
You want to enlarge the scope of the application. Admission according to you is in page 57, 58. Right?
Please, my lord.
Yes.
57, page number 58.
Correct.
He says that the document is in his locker. ನಾನು ಹಾಜರುಪಡಿಸುವಂತ ನಿಶಾನೆ D1 ಇಸಿವಿ ತಯಾರಿಸಿದ್ದಾರೆ ಎಂದರೆ ಅದನ್ನು 1965ರಲ್ಲಿ ತಯಾರಿಸಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರ.
It is the petitioner is before this court calling in question an order dated 15/3/2025 by which an application in IA-10 filed by the petitioner plaintiff under order 16 rule 6 seeking production of an agreement comes to be rejected. The petitioner is the plaintiff, institutes a suit in OS 6687 of 2016 seeking declaration and injunction against the petitioners, against the respondent defendants. The suit has traveled thus far up for close to 9 years. An application comes to be filed by the petitioner in IA-10 under order 16 rule 6 seeking production of a document which according to the petitioner would be imperative for a resolution of the issue in the suit. To buttress the submission, the learned counsel for the petitioner takes this court through the cross-examination of PW1, DW1, cross-examination of DW1 to DW1. The relevant portion of the cross-examination on which the petitioner places reliance upon reads as follows. Page 57, 58. On the strength of the said cross-examination comes the application in IA-10. This is answered by the concerned court rejecting the same on the following reasons. Page 14, 15. The concerned court holds that the defendant number 2 has contended that the officials have conducted a search in the office lockers of the company and the same is not readily traceable in spite of its best efforts. And holds that the petitioner has filed a suit for declaration and permanent injunction. So it is his burden to prove towards the relief that he has sought for before the concerned court, and the application comes to be rejected. The learned counsel would reiterate the submissions that are made in the contentions of the applications in IA-10 to contend that the document has to be produced before the concerned court, which is in the custody of the respondent. The learned counsel Bipin Hegde, representing the respondent, would submit that the document that is not in possession cannot be compelled to be produced. He would seek to place reliance upon the judgments rendered by the coordinate benches of this court. In 2013 SCC Online Karnataka 7057, wherein the coordinate bench answering an identical issue has held as follows. Para 10 to 8 to 12. Following, after the said judgment, two of the other coordinate benches have also followed suit in observing that a document that is not in custody or not traceable cannot be compelled to be produced by the petitioners. The learned counsel for the petitioner places his entire reliance upon a bleak cross-examination of DW1 who does not unequivocally depose that he is in custody, the document is in his custody. He would say that the GPA or the agreement, as the case would be, will be produced, but again clarifies that he has never seen the said document. So in the light of the said cross-examination, in the light of the said cross-examination, which is not free from equivocity, the petitioner cannot make the foundation of the application on the said cross-examination. It is for him to prove the relief that he has sought on the documents that are placed before the court. In the light of the law laid down by the coordinate benches, I do not find any warrant to interfere with the order that is passed by the concerned court.
Lordship,
Yes.
the cross-examination at page number 58.
Order agide. Yes.
It has been admitted in the cross-examination that it is in their locker.
Yes. Anything else? Next. Forty?
46.
46.
I appear for the petitioner.
Hmm.
Petitioner challenged the orders on IA number 4 for submitting the interrogatories on the
The
defendant.
petitioner is before this court calling in question an order dated 5/2/2025, which rejects an application in IA 4, which they have filed by the petitioner seeking interrogatories from the hands of the defendants. The concerned court prima facie has erred that interrogatories cannot be sought for by way of the application. In that light, further proceedings before the concerned court shall remain stayed. Next.
47. In this case, my lord, soon after the marriage, my lord, since the.
Soon after the marriage, ಏನಾಯ್ತು?
My lord, the respondent.
MC petition ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು?
Seeking for early disposal.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಗೆ ಇಲ್ಲಿ ಬರಲ್ಲ, GM ಹೋಗ್ಬೇಕು.
GM ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಅವ್ರಿಗೆ.
CPC ಅಂತ ಹೇಳಿದ್ರು ಅವರು.
ಇಲ್ಲ GM ಅಂತ ಬರ್ದಿದೆ, ಆಮೇಲೆ GMC FC ಅಂತ ಬರ್ದಿದೆ, CPC ಅಂತ ಮಾಡಿ.
GMFC. The petitioner is before the court seeking certain relief of disposal of the petition before the family court. The matter be appropriately classified and posted before the appropriate bench. Yes.
48.
For the petition.
Which clause in the compromise says 20K? Page.
Compromise, page 18, my lord.
Which clause, sir?
Clause is not there.
Gift deed ಮಾಡಿದಿರಾ?
Yes, sir.
Gift deed ಇದೆಯಾ?
Gift deed was there, my lord. They have
Gift
challenged.
deed ಅಲ್ಲಿ ಇದೆಯಾ 20,000 ಅಂತ? Compromise ಯಾವ clause ಅಲ್ಲಿ ಇದೆ?
Compromise clause.
ಓದ್ಕೊಂಬನ್ನಿ. List on 25th in preliminary hearing. Next.
Friday, my lord, this Friday.
Friday, sorry, 18th.
No,
Appearing for the petition.
serial number 49, I appear for respondents 3 to 6. Whether I may be permitted to file my objections, my lord. I pray for 2 weeks' time.
But who is the petitioner?
I am appearing for the petitioner.
Adaithu, who is the petitioner, sir? Who are the petitioners?
Petitioner is impleading, made an application for impleading them as a party.
Who are you first ಹೇಳಿ impleading application ಆಮೇಲೆ compensation ಬರುತ್ತೆ ಅಂದ್ರೆ everybody will become relatives.
I am one of the legal layers. And my lord,
Legal
similarly,
heir to relative spring only after compensation is determined.
the page, kindly see annexure B
Let him
page. my
file
lord.
his objections. Learned counsel R.V. Jayaprakash seeks a week's time to file statement of objections. List the matter on 23rd. Objections, if any, by then. Next.
50.
Appeal for petition, my lord. Petitioner filed this petition.
The
seeking-
petitioner is before this court seeking the following prayer. The petitioner is defendant, huh?
Respondent.
Petitioner is the
Respondent
respondent in
miscellaneous
the,
case.
before the concerned court in miscellaneous petition 427 of 2021, which is said to be pending before the concerned court for the last 4 years, and there is no progress in the said petition. The said petition is preferred on account of an ex parte decree that is passed against the petitioner. The concerned court ought to have realized the urgency and closed the proceedings in miscellaneous petition 427 of 2021 by this time. In the light of the said prayer and it being innocuous, I deem it appropriate to direct the concerned court to dispose miscellaneous petition 427 of 2021 within 6 weeks from the date of receipt of the copy of the order, if not earlier. Ordered accordingly. Next.
P1.
Lord, plaintiff's petition, my lord, seeking speedy disposal of the suit. Suit is of the year
Memo of
2016, my
calculation.
lord.
Yavudu? 50?
Lord, 51.
You are decree holder.
Yes, I am decree holder.
In expeditious disposal.
No. This is not, my lord. He is appearing for the 52. The interest is been
Correct.
awarded.
Memo of calculation.
The annexure J.
Hmm.
They have not disputed or objected the interest rate what the decree holder has been claimed. But the award is only 6%. The lower court is been calculated.
Learned counsel.
Copy is not, sir.
ಎಲ್ಲರೂ ನೀವೇನಾ?
ಎಲ್ರಿಗೂ. sorry.
ಇಲ್ಲ, ಬಂದಿಲ್ಲ sir.
I'm sorry.
ಎಲ್ಲರೂ ಸ್ಟೇಟ್ ಏನಾ?
ಹೌದು
ಹೌದು,
sir.
state.
State ಇದೆ, ಕಾಪಿ ಇನ್ನು ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ಕಾಪಿ ಸರ್ವ್.
Learned HCGP is directed to accept notice for all the respondents, the petitioner to serve set of papers upon the aforesaid council 30th.
Please.
Yes.
52.
Ida disposal.
Speedy disposal. Speedy disposal, my lord. Suit is of the year 2016. It was transferred to Kerpuram, my lord. Order sheet is at page 57.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff, institutes a suit in OS 105/23 antide.
Adu transfer admele 105/23.
Institutes a suit in OS
1106 of 2016.
1106 of 2016.
Yes.
2016, and after it is transferred to the concerned court now has been renumbered as OS 105 of 2023. However, the fact remains that the suit is of the year 2016. The learned counsel for the petitioner also takes this court through the order sheet appended to the petition, which depicts umpteen number of adjournments being granted for the examination in chief. Conclude agidya.
Chief is concluded. It is for
Umpteen number of adjournments being granted for the asking for cross-examination of PW1 at the hands of the defendants. The learned counsel will suit for
partition.
Partition
It is now 9 years, my lord.
Partition
One of the
anyway.
plaintiff is 70 years old. She is being examined as PW1.
Though the suit is for partition and the observation of the apex court that the timeline should not be fixed, the issue is that the suit is 9 years old and the parties to the suit are now of advancing age. In that light, I deem it appropriate to direct the concerned court to endeavor to conclude the proceedings with an outer limit of 9 months. 9 months. Partition mugiyala. 9 months from the date of receipt of the copy of this order, if not earlier.
Great.
Ordered accordingly.
53.
Amendment sought in the prayer, Your Lordship.
Demolish madak ಕೇಳಿದಿರಾ?
Yes, Your Lordship.
Entry model demolition ಕೊಡಕ್ಕಾಗತ್ತಾ? Notice ತಗೊಳ್ಳಿ. Yes.
Lordship.
ಏನು?
Prayer, Your Lordship, that is what we are sought, Your Lordship.
ಏನು?
Declaration for declare, that is now the amendment.
What is the application that you have?
Application for amendment, Your.
What amendments?
Amendment, Your Lordship, get it at page, Your Lordship.
Serial number
Annexure E.
52 na idu.
53.
53, ಏನ್ prayer?
Your lordship will get the page, prayer in page 26. Suit prayer.
1 minute, sir. What amendment you wanted to bring
Now
in, sir?
want your lordship, it's the amendment sought your lordship, to declare the plaintiff is the owner of Khatedar of scheduled property. The formulation of the prayer is not in the correct format. That's the whole thing, your lordship.
Emergent notice to the, petitioner to serve on the counsel representing the defendants before the concerned court. List the matter on 23rd. Further proceedings before the concerned court till the next date shall remain stayed. Next.
Great.
54.
Plaintiff's evidence, he doesn't need evidence.
That's what, existence of a common wall.
Yes, and that has been rumored long ago. Now the appointment of a commissioner.
No, otherwise there was no need for appointment of the commissioner.
No, there was
here.
no need. And kindly see the application at page 22. It's
That
omnibus.
that is bald. Yes. Heard the learned counsel Mandan appearing for the petitioner. Petitioner shall serve on the counsel who represents the respondent in the subject proceedings. Suit for what?
Suit for mandatory, declaration and mandatory.
The suit is filed by the respondent plaintiff seeking injunction against these petitioners. In the said suit comes the application under Order 26 Rule 9 seeking appointment of a court commissioner to inspect the property and assess the common wall if necessary. The application does not indicate as to why it was necessary nor the order of the court. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Next.
55.
Petitioner is the plaintiff.
The petitioner, the plaintiff calls in question an order date, order dated ಯಾವ ಡೇಟ್ ಇದು? 6/2/2024.
Order dated, my lord. But annexure,
617 is rejected.
page number 40, my lord.
With date ಹೇಳಿ ಸರ್.
8th February 2024, my.
24. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
He is a disabled person, my lord.
So
The advocate also did not inform me about the same. And after coming to know, he has immediately secured the certified copies and approached this. He's met with an accident and he could not move.
You are a family member?
They are all dependents and plaintiffs are all.
The suit is instituted for partition. Petitioner is a member of the family. The application seeking amendment of the plaint is rejected on the score that it has been preferred after 2 years. In the light of the suit being of partition and inclusion of certain
Not on that ground, my lord. The trial court has held that it is, the plaintiff has not produced any document to show that it family property belongs to family.
No, first, are you a family member?
Yes, my lord. Your lordship may kindly page number 4 of the plain petition, my lord. I have stated family tree I have depicted.
Anyway, we'll see, we'll hear the respondent. So and so. The petitioner shall serve on the counsel who represents the defendants before the concerned court and file an acknowledgement of such service by the 11th. List the matter on 23rd. Further proceedings. Stay back. Yes. Next.
56.
Petition.
Permission ಕೊಟ್ಟಿಲ್ವಾ?
Only.
ಯಾಕೆಲ್ಲ
Delay ಮೇಲೆ.
ಯಾವ ಡಿಲೇ?
2012 ಸೂಟು 1924 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀವಿ.
24 ವಿಡ್ರಾಲ್ ಹಾಕಿದ್ದೀರಾ?
ಅಂದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ 23 ಸ್ವಾಮಿ.
ಮೆಮೋ ಹಾಕಿದ್ದೆ ಯಾವಾಗ?
Application was.
Why withdrawal? Unless it is jurisdiction, I will also not permit.
No, in injunction suit, I have admitted that the defendant is in possession. That's why I made an application to withdraw suit to file with the liberty to file comprehensive suit for declaration in possession.
ಇದು ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಮಾತ್ರನಾ?
ಹೌದು.
12 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಮಧ್ಯದಲ್ಲಿ ಕೋವಿಡ್ ಬಂದು ಇದಾಗಿತ್ತು.
ಮಧ್ಯ ಕೋವಿಡ್ 19 ಬಂದಿದೆ ಸರ್.
ಕರೆಕ್ಟ್ ಅಲ್ಲ, ಇವನು ಖಂಡಿಸಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ 2023.
ಅಲ್ಲ 12 years 2012 ಇಂದ ಕೋವಿಡ್ ಬರ್ತಾ ಇತ್ತು.
ಅಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ ಅವಾಗ ಸ್ವಾಮಿ, ನಾವೇನ್ ಟೈಮ್ ತಗೊಂಡಿಲ್ಲ. Otherwise, I will lose my right, man. I will establish my right title over the property. As on today, until admission ಕೊಟ್ಟಿದ್ದಾರೆ because COVID time ಅದಕ್ಕೊಂದು application ಹಾಕಿದ್ವಿ.
ಮತ್ತೆ
COVID time ಅಲ್ಲಿ they tried to interfere. That made an application that also pending. Cross examination ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. As on today, they are in position ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೋಸ್ಕರ.
You serve on the respondent. The petitioner to serve on the counsel for the respondent before the concerned court. List the matter on 25th.
ಇವತ್ತು final argument ಗೆ ಅಂತ ಇದೆ permission.
Yes, no ground even to issue notice. Next.
C7.
Partnership firm of 3 partners.
Adverse inference against the plaintiff. Why?
Yes. Now, 3 partners, one died during COVID. The widow is before the court. She sought for rendition of accounts to ascertain the share of a deceased partner. An interim order was passed directing them to furnish the accounts as prayed for, which is almost equal to prayers 1, 2, and 3 in the main counterclaim. With impunity and for no reason, despite an order of the court, they would not furnish the accounts. So I'm only a widow. I've stepped into the court. I can only ascertain on the basis of what information I have as to what is appropriately the value of my husband's estate. We valued it tentatively because in a suit for rendition of accounts, I have to show.
No right to cross-examine will not grant.
That's the only issue. That's the only issue.
That is stretching it too far. I will not grant an order of no right to cross-examination.
An adverse inference has been.
Not at all.
Lordship has
That order, no money answer.
My lord will see. May I ask the question? I'm being very fair to the court and to my friend over here, who has with impunity disobeyed the order of the court.
Correct.
Kindly see the main relief in my counterclaim.
You should file something else, not cross-examination being taken away.
May I ask, my lord, if
Striking off a defense is
I
always,
just want to
striking
make
off a
this
defense is always there.
My lord, there is a proceeding pending regarding that. And
also
we moved an application. May I make the submission to the honorable court? My lord is right. We did move an application for striking off defense, which came to be rejected on a very specious ground that after the.
You have not challenged that?
We have
Where is it?
challenged.
And no stay granted.
No.
Another petition is there?
It is pending.
Commercial, what happened was he filed an application for striking off defense. In commercial courts, the CPC as applicable does not contemplate that provision.
No.
Therefore, when he filed an
No,
appeal,
that
the
is
appellate
quite
court
right. That is
refused
a
to
mistake which was misled by my friend and the court made the mistake. What the wordings are, my lord, very quickly.
That's all right. Which is that petition? Tell me.
Commercial.
If that is pending, tell me.
Yes, it is, my lord.
Give it. Yes. Tag this petition along with so and so day after tomorrow.
Please.
Go before the division.
Division bench go.
Division bench commercial.
37 na?
37.
It's an appealable order.
Oh, 37 adre tag
It's an appealable order. Well, there it's a completely separate application, completely separate order.
Now, my lord will see this.
Right to cross-examination.
No, may I make the submission? My lord will see that my lord is right. Right to strike off defense is something which my lord had suggested. Order 11 as it originally stood had this right to strike off the defense. By way of an amendment to the Commercial Codes Act.
No, that the division bench is hearing, we will not step into that. But cross-examination, I cannot, it will not be permitted to be taken.
The reason is this. May I just make this one submission and then I'll request.
Even in the
court.
worst circumstance, cross-examination.
Only for this reason, my lord, if I just make that statement,
Yes,
my lord will
yes,
consider
yes,
this.
Yes.
There is an order of this court, a coordinate bench, where in a writ petition filed by my friend challenging the order directing them to furnish the statement of accounts, it was dismissed. And in the course of dismissing that writ petition, my friend said that it is always open for the court to draw an adverse inference. And this court passed an order.
To draw adverse inference.
Absolutely. My lord will find that order. Now, if I permit cross-examination, it will be contrary to that order.
Page.
Kindly see page number
51.
50.
55 is the operative portion, 51 is the order.
97.
55 is the operative. It emerges from.
Yes, 55.
What do you mean drawing of adverse inference?
And at the end of the trial, if it is established, because in Ibrahimuddin, my lord, what is the concept of adverse inference is explained by the Supreme Court. Adverse Ibrahimuddin anta ivagilla. The adverse inference has to be drawn at the end of the trial. Adverse inference does not contemplate that it cannot be done.
Fair judgments.
Ibrahimuddin Lalla, but tamdenne on the decision I'm relying on, where in a section 138 petition, there was a direction for interim compensation to be paid. The accused had to pay interim compensation. This, the accused did not pay interim compensation, did not comply with the order.
My order.
Lordship's order relating to forfeiture of cross-examination, how it is not permissible.
No, cross-examination, it's difficult, but there is an order of the coordinate bench saying,
Adverse
what is drawing of adverse inference at what stage? You have something?
Ibrahimuddin,
No, you have some judgment on that?
230, my lord, Supreme Court Ibrahimuddin, that is the judgment.
May I bring it a submission? My lord is asking a very pointed question, whether an adverse inference, is there any law which says that adverse inference has to be drawn at the conclusion of trial?
Or cross-examination should be taken away under the heading adverse inference.
My lord, the straitjacket, I can get you a citation, there are no difficulty, with some research it can be done. But kindly see, the scope of the suit is only for rendition of accounts. As a widow.
No, that's not on law.
Not on law. Kindly
The
see.
widow on takshana, the sympathy jurisdiction.
Kindly, okay, forget the widow. Kindly come to the counterclaim prayers. Kindly see the counterclaim prayers at page number 80. Let me. '87, 85 onwards. Kindly see prayers 1 and directing them to furnish accounts. In fact, prayers 1 and 2 have already been granted.
This we'll have to see. I'll take a day after tomorrow.
Please.
Not with that, but
Today,
could you
230, my lord.
give it? No, we'll take it day after tomorrow.
The only issue is no problem day after tomorrow. It's listed for cross, a short accommodation, my friend. I'm not asking for any interim order. My friend should cooperate, informing the court that this matter is court is seized.
Day after tomorrow, I'll take it.
For the last 1 year, this is the same thing.
All right. Day after tomorrow, I'll take it. Don't precipitate there.
Not grateful. Not.
58.
For the respondents counsel.
Petitioner
There's been no deposit made, my lord, despite your lordship's last order, and that appeal that they said has also not come up.
We'll vacate it.
No, my lords, I'm given.
This court on 26/20/2025 had passed the following order. On 36/20/2025, the following order. It was made clear that on 9/7/2025, if the learned counsel would not place on record any order passed by the coordinate bench, appropriate orders would be passed. The matter was posted to this day. Even today, the petitioner has not produced any order passed by the coordinate bench in MFN other.
But it would be a commercial appeal problem.
In the commercial appeal division bench.
Division bench ಹೋಗುತ್ತೆ. Not coordinate, ಅವ್ರು ಹೇಳಿದ್ರು coordinate bench ಅಂತ but.
Division bench.
Division bench.
ಅದೆಲ್ಲ madam coordinate bench ಅಂತ ಹೇಳಿದ್ರೆ division bench ಮಾಡಿ. Before, no, it has not produced any order passed by the division bench in the commercial appeal. In that light, intermodally.
ಇಲ್ಲ, I had made a submission that we will take an adjournment. Your lordship may discharge me, permit us to proceed with the execution.
All right. In that light, the pendency of this petition will not come in the way of further proceedings before the concerned court.
If I may be permitted to make, my lords, it was supposed to be listed today, but unfortunately it is not. We've moved another memo today, and I have given to her,
No, let them
understand
deposit
that
there.
it's
I will naturally not, let them take
ಎಷ್ಟಿದೆ?
it. 50 lakhs was originally, now with the calculation, it comes to close to about 90 odd lakhs. Their property, they says 15 crores, let them deposit, I have no difficulty. Inter-se partnership.
The execution is for 50 lakhs, 1,12,000 has already been.
Deposit ಮಾಡ್ತೀರಾ? Subject to what the division bench would say, you deposit.
As I need to seek instructions. If my
You
lords
don't
may
take
pass
it on you,
over.
I'll pass it over, you seek instructions and come. Yes.
59.
The petitioner shall serve on the counsel who represents the respondent defendant before the concerned court. I'll represent ಆಗಿದಾರಾ?
ಆಗಿದೆ ಸರ್.
Concerned court. List the matter on 30th till such time further proceedings before the concerned court shall remain still. Next.
60.
But I'm filing counter.
Counter.
Well, I'm only.
Notice ಆಗಿದೆಯಾ?
And what is
Undertaken notice on the last date of hearing.
Last date of hearing ಅಲ್ಲಿ.
Undertake ಆಗಿತ್ತು. Oh, sorry, sir. Sorry.
Counter is.
I kindly begin. This is the defendant number 1 to 4's writ
You
petition.
want to see the counter?
I received it now.
Then I should see and make submission. Maybe you have a better case
Please.
after looking at the counter.
Tomorrow, my lord, if it is convenient.
Not tomorrow, day after tomorrow.
Day after
Madam,
tomorrow.
list ಕೊಡಿ madam. Dates.
Issues.
16th.
My name is not shown. I am Anant
We'll,
Narayan.
we'll show it. We'll take it on 21st,
21st.
Monday.
My lord, 16th, the matter is before the trial court for framing of issues.
Issues here, nothing will happen. It's for issues here.
Issues ಗಿದ್ಯಾ?
Issues again.
Let the court defer it till the next date. List the matter on 21st. What's the issue here?
My lord, I'm challenging the additional documents that are filed by the respondent number 1 plaintiff.
Order 1, Rule 11.
Order 1, Rule 11 for the second instance.
11 rule 1.
11, Rule 1.
11, Rule 1. Second
11,
instance.
Rule 5. Why second instance?
The first instance, he has already, if my lords may kindly see page 33 of the order sheet.
No, is it,
This is the second time.
are you on the proviso?
It's not on.
We are on the proviso. However, in the first instance, he had, during when he was leading his ex parte evidence, it can be seen at page 33 of the order sheet. He had already filed an additional documents by way of a memo on 19/6/2024. Subsequently, after the suit was restored and I was allowed to file my written statement, at page number 38, he files an IA under order 11 Rule 1.5.
Correct.
Seeking to file one more set of additional.
No, 1.5C is it?
1.5C is interpreted by the learned trial judge. But if one were to look at the IA that is filed at page 135, no grounds has been made out. He only says he was under the impression that these documents were already placed on record. Page number 136, if I may read kindly. It says, I was under
Which was the first instance where this was permitted?
It is at page 33 of the order sheet. No IA was filed. It was simply taken on record during ex parte evidence proceedings.
When did you file your written statement?
My written statement, my lord, was filed subsequent to the 7/4/2025.
Was the first set of documents produced after the written statement?
No.
No. This is permissible. Anything else?
My
To
only another
set up
contention.
the defense taken by the defendant in the written statement, documents can be produced is the law.
May I kindly
is
request the
C2.
honorable court to refer to exhibit
That's what
D2.
the trial court has.
ಇದೆ some trial court
Annexure
also said
D2, my
last
lord,
para of
kindly.
the order.
I have myself interpreted that.
I understand, but request my lord to kindly consider annexure D2.
Very recent, last week or 15 days.
I am aware of the judgment.
Then you should, what is this?
ಇದರಲ್ಲಿ exhibit D2 ನೋಡಿದ್ರೆ, in my written reply notice, which was also marked, I had taken the contention that there was no privity of contract between me and the plaintiff. The same response has been reiterated in my written statement. And this contention in exhibit D, in annexure D2, was also analyzed by the learned trial judge in the ex parte judgment and decree at annexure H at page 78.
No, whatever, it's just production of document. It does not amount to proof unless it is proved. Nothing. Because I myself held that under C2, 111C2.
This is the only distinction on fact that I would like to make here.
No, 1115.
11.2. 11.1C2.
C2 permits after filing of the written. That's why I asked whether the earlier documents were after the written statement or prior to the written statement. That was not on an application anyway. This is permissible. To set up the defense on the written statement, it is permissible.
But he only says that he was under the impression that it was already filed.
Reason,
This
we'll see, yes.
May I kindly at least, could it be held on 21st? I will analyze the
Please,
objections of the.
Yes, you have not seen the judgment?
Not yet. No, the judgment I've seen, the objections I would like to kindly.
Correct. That is a better way, yes. List on 21st at the request of the council.
Much obliged.
Yes.
the
Covered,
application. Yes, my lord, that I said.
After lapse
Even,
of one.
even after one submission, even after passing of this order, my lord, impinged order, I moved an application 151, bringing to the knowledge of the court that this is the error has happened. That's why the matter was delayed 1 year. And subsequently, that application also dismissed with the cost. Hence, I challenged it. And
Lord, after lapse of 1 year.
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ಅಷ್ಟೇನ ಅದೊಂದೇನ ಗ್ರೌಂಡ್?
Yes.
Then it is covered by this order.
Kindly direct to the petitioner to file a necessary application for modification
No,
of
no,
the
no, no.
preliminary decree, my lord. And also, my lord, kindly kept in
ಈಗ
abeyance the
ನಾವು
commission-
whatever the coordinate bench has said, we will only follow it. In accordance with law, what he has to do, he will do it.
I have filed objection in the preliminary decree itself for modifying the order.
ಈಗ allow
Preliminary
ಮಾಡ್ತಾರೆ.
decree. Yes, well.
In terms of the order of the coordinate bench, yes. Is an
kept in abeyance the commissioner report.
Commissioner report ಏನಿದೆ ಇಲ್ಲಿ?
Report ಹಾಕ್ಲಿಲ್ಲ, order
Commissioner
is
order, my
passed,
lord.
for which
Report
they have
ಇಲ್ಲ,
not paid.
commissioner order.
Then commissioner order, let it be kept in abeyance till then.
Abeyance ನಮಗೆ notice ಆಗಿಲ್ಲ. He has not done any work, it seems.
We'll direct the court to take appropriate action, yes.
Till this date, they have not disclosed the rent, my lord.
Allowed,
Yep, yep,
yes.
yep.
Allowed in terms of this Suraj Govindra Sabar order ಇದೆ ಅಲ್ಲಿ. Next.
62.
Let's start for direction, time-bound direction to dispose earlier.
What suits, sir?
Because my lordship he is already 69 years old.
Suits, sir?
Suit for declaration, my lord.
Correct, sir. ಯಾವ ವರ್ಷದ sir?
24.
24. List in 2026. ಏನ್ ಕೋರ್ಟ್ಗೆ ಅದೇನು ಇದಿಲ್ಲ.
Petition is aged about
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ sir.
69 years.
80 years old ನೋಡ್ದು ಇನ್ನೂ suit pending ಇದೆ.
Preliminary
Nothing
stage.
doing, yes. The petitioner is before this court seeking the following prayer. The suit is for injunction.
Declaration.
A suit for declaration and possession is instituted by the petitioner in OS so and so. He is before the court seeking expeditious disposal within a time limit to be directed to the concerned court for disposal. Since the suit is of the year 2024, this court would not direct conclusion of the proceedings within a time frame. Petitioner is at liberty to move the application in 2026 if the suit is still pending. Next, yes.
Expeditiously. My lord.
Nothing, yes. Ordered accordingly. ಇಪ್ಪತ್ನಾಲ್ಕದಲ್ಲ ಅದೆಲ್ಲ
He is 69 years old.
80 years not ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್ ಇನ್ನು. ಏಜ್ ಪ್ರಕಾರ ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾ ಹೋಗ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಮುಗೀತು. ಎಸ್.
Your lordship had asked for the orders which is passed in the trial court. My lord, the matter was transferred to the JMFC Kyarpura. The file is still under segregation.
You want one more week?
There were no proceedings.
Are they represented before the court now?
No, your lordship, they are not.
You get the order sheet.
Your lordship, it will take some more time because the proceeding itself is not happening. It's still under segregation.
List the matter on 21st. Yes, next.
64.
Concurrent.
Suit for bare injunction.
Correct. ಎರಡು ಕಡೆನೂ ಹೋಗಿದೆ.
ಹೌದು.
ಅದು 23ರಲ್ಲಿ.
24ರಲ್ಲಿ
23 ಫಸ್ಟ್ ರಿಜೆಕ್ಷನ್. 24 ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, 24ರಲ್ಲಿ ರಿಜೆಕ್ಷನ್, 25 ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್.
ಯಾವಾಗ 25 ಎಲ್ಲ ಆಗಿದೆ?
ಮೇ 2025 ಅಲ್ಲಿ.
ಏನ್ ವಾಟ್?
So bare injunction suit ಅಲ್ಲಿ 39(1) was rejected by the trial.
Correct, rejected, ಹೌದು. Granted.
39(1) was rejected by the trial court.
First appellate court has granted
Yes,
it.
my lord. ಇದರಲ್ಲಿ they are claiming under tenancy acts ಪ್ರಕಾರವಾಗಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ. RTC ನಲ್ಲಿ
ಏನ್ ಹೇಳಿದ್ದಾರೆ? not to interfere.
not to interfere ಅಲ್ಲ, ಅವ್ರು ಕೇಳಿದ್ರೆ not to interfere ಅಂತ ರಿಜೆಕ್ಟ್ ಆಯ್ತು, ಮತ್ತೆ ಅದನ್ನ ಇದು ಮಾಡಿದ್ದಾರೆ. We are in possession of the property. RTC ನಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 12 ಅಲ್ಲಾಗ್ಲಿ 9 ಅಲ್ಲಾಗ್ಲಿ ಅವ್ರ ಹೆಸರು ಇಲ್ಲ.
Petitioner to serve on the counsel who represented the plaintiff before the concerned court and file an acknowledgement of such service by the 11th. List the matter on 30th. The order of the first appellate court dated 17/4/2025 shall remain stayed till the next date of hearing.
Grateful.
Next.
55. This is for respondent number 1.
26/9 application ಈಗ 15 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ what happened, they were impleaded. The ground defense is that it is a road. I claim it is a site granted by the Hebbal municipality. If it is a road, my approach should be different, either for damages or for alternate site. ಇನ್ನ ಟ್ರಯಲ್ ಶುರು ಆಗಿದೆ ಅಷ್ಟೇ. it will take 2 years for completion of the trial. If the commissioner
2010
reports,
ಆಗ್ಲೇ 2 years fix ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಆಗುತ್ತೆ. Commissioner report ಬಂದ್ರೆ I may have to take some other
Oh, yes madam.
road ಅಂತ ಹೇಳ್ತಾರೆ.
Appealing for respondent number 1 million.
BBMP na.
Road ಅಂತ defense.
Serve on the defendants, yes.
ಆಯ್ತು.
Petition. Copy ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲ.
The learned counsel, what's your name madam?
Lavanya.
Lavanya V. HB appearing for the respondent, PBMP shall secure instructions with regard to the existence of the road or otherwise as is claimed by the petitioner by the next date of hearing.
ನಾನು ರೋಡ್ ಅಂತ ಹೇಳ್ದೆ. ನಾನು ಸೈಟ್ ಅಂತ.
Respond by the defendants. The petitioner shall serve on the counsel representing respondents, defendant 2 and 1, defendants 1, 2 and 3 before the concerned court and final acknowledgement of such service. List on 25th information be secured by then till the, yes, next.
Date is then.
Yeah, next date ಯಾವತ್ತು?
Date ಗೊತ್ತಿಲ್ಲ.
ಇರ್ಲಿ. 25th, yes.
Much obliged.
Petitioner, Lord, my application to treat the additional issues as preliminary issues on the issue of court fee and limitation comes to be rejected. Lord, my ground is that it is valued under section 24 and only rupees 185 has been paid. Lord, however, my contention is that the land is already being converted, court fee has to be paid on market value. Under section 11(2).
When was it converted, sir?
Lords, in the year 1999, Lords, I have produced the conversion order also at page number 61.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement 30th till such time. Further proceedings shall remain stayed. Next.
I'll seek dispensation of notice to respond number 2
Memo.
to 5 minutes. Sir.
Dispensation, ಯಾರ್ಯಾರಿಗೆ?
Respond number 2 to 5 minutes. They are
2
not.
to 5. Yes,
Much
at the risk. Next.
67.
67 may be passed over, but senior election council.
PNDC clubbing? Yes.
PNDC and partitions would club.
Pass over.
Much obliged.
Okay.
This case, I kindly see. After posting the matter for judgment, the defendant has filed an application. under
The petitioner is before the court calling in question an order allowing an application under Order 6 Rule 17 by the defendant.
151.
150, read with 151 by the defendant at the stage of conclusion of the proceedings. The allegation is that the concerned court has repeatedly allowed such applications filed by the defendant without any rhyme or reason. In that light, there shall be an interim order of stay of further proceedings. Interim order of stay of the order dated 4/4/2025 till the next date of hearing. Yes, next.
69.
ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದಾರೆ ಈಗ?
18th is the next date. 18th is the next date.
ಬರ್ತಾರೆ ಬಿಡಿ.
ಇದರಲ್ಲಿ
ಇಲ್ಲಿವರೆಗೆ ಏನಾಗಿಲ್ವಲ್ಲ?
Flood, the suit for bare injunction. Flood, so only we have entered into a MOA with the defendant to enable to enter into a joint development agreement. So because of shortage of funds, the contract could not be finalized. So ಈಗ second MOA ಮಾಡ್ಬಿಟ್ಟು ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ನಮ್ಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು the annexure G. And in spite of that, now they are trying to interfere. We have not delivered any possession under the MOU also, but still, so it was only agreed for development, but the contract could not be concluded on account
Place
of.
the matter on 21st in preliminary hearing. The petitioner shall serve on the respondents by way of hand summons. Further proceedings before the concerned court shall be deferred till the next date of hearing.
Hold on. Stay, Lord, I'm seeking for status quo, both the part.
Yes.
Stay and the
Parties to
proceedings.
maintain status quo till the next date of hearing. We will direct you to go there only on Monday. Serve ಮಾಡಿ ಕರ್ಕೊಂಬನ್ನಿ.
Obliged.
In the event no steps would be taken to serve the respondents by way of hand summons, interim order would get automatically vacated.
Please, I'll counsel instead of hand summons because the parties, not if they appear on 18th.
Appear ಆಗಿದಾರಾ?
18th is the next date, not at appear.
Appear ಆದ್ರೆ ಮಾಡಿ. The petitioner is also at liberty to serve on the counsels in the event they represent the defendants before the concerned court on 18th. Next.
70.
Appellate court had no jurisdiction
for the reason that it is covered by
Bifurcation of
bifurcations, it is not permitted.
the petitioner shall serve on the council who represents, who is the contesting plaintiff matrala?
Plaintiffs, respondents,
Respondent all,
ಹೌದು.
defendant one ಅಂತಿದೆ ಇಲ್ಲಿ.
Defendant number 1 and 2,
You are defendant sir.
ನಾನ್ defendant,
ಅಲ್ಲಿ ಪ್ಲೇ ಯಾರು contesting ಹೇಳಿ.
contesting respondent number 1 and 2.
Second, first defendant.
ಅಲ್ಲ, respondent number 1 and 2, the
One is plaintiff, two is defendant ಅಂತ ಹೇಳಿದಿರಾ?
client I have furnished, Anuradha and Mahesh,
Correct, ಅವರು 1 and 3.
1 and 3,
ಮತ್ತೆ 2 ಅಂದ್ರೆ?
1 and 3.
Yes, petitioner to serve on the council who represents the plaintiffs 1 and respondents 1 and 3. List the matter on 30th. Further proceedings before the concerned court shall remain stayed.
Obliged.
Next.
71.
This matter, there is a connected matter.
So what if properties come in, all properties partition.
Yeah,
You are there.
Yes, I move for appear for the petitioner.
What are you challenging?
Lord, the application, my lord, whereby I seek to include properties.
That is rejected.
That is rejected.
My lords, I'll explain, my lords. What's happened in this, my lords? There was
Partition, suit for partition.
My lords, the suit for partition was filed in 1948, 1949. My lords, on
1948,
49. My lords, on 17/7/54, there was a compromise between the parties wherein there was a partial compromise and certain properties fell to the respective shares. Now, my lords, my learned friend's client's father himself admits to the earlier partition and he takes the properties. Now, my lords, the FTP is filed in 2004. The FTP deals with properties
Preliminary decree.
arising out of the 48-49 suit. The FTP is filed in 2004. Now, the FTP pertains to certain properties which have been left out, my lords. And these properties, now what they are seeking to do is include properties which already stand partitioned and have fallen to the respective shares of various parties. Now, my lords, in the companion matter also, my lords, which was before my lords on the earlier date, now that is listed for the 25th.
We'll take this also on the same.
Very well, my lords, because I already have the compilation. And my lords, proceedings after proceedings, parties after parties have admitted to the earlier partition. There is no dispute in that.
List on 25th, tag the petition along with so and so.
I'll just
6607 of 25.
Next.
Grateful.
There the interim order was, they wanted to divide the properties.
But there is already interim order in the connected suit
List
not
on-
to appoint the
list
court
on
commissioner.
25th.
It continues, my lord.
ಅದು ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ವಲ್ಲ ಕಂಟಿನ್ಯೂಸ್ ಅಂತ ಹೇಳಕ್ಕೆ.
ಅಲ್ಲ,
That is
same
not
order-
listed.
Same order.
ಬೇಡ ಬೇಡ ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ ಸಾಕು.
And my lord,
May permitted to file wakalat for the respond number.
Registry ಇಲ್ಲ.
72.
My lord, another writ petition in respect of other two applications is pending, my lord, 4208. That may kindly, on Monday it may kindly be.
Numbers ಕೊಡಿ.
So 4208, my lord, of 25.
208 ಅಂದ್ರೆ
3408, 3408.
ನಂಬರ್ ಬರ್ಕೊಡಿ ಎರಡು.
ಇದರಲ್ಲಿ ಬೇರೆ, ಅದ್ರಲ್ಲಿ ಬೇರೆ.
ಅಲ್ಲ, same suit.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ, stay ಇಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಕೊಡೋಣ.
ಅದೇ
ಬೇಡವಾ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಅದೇನ್ ಸರ್ವೈವ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್.
ಅಲ್ಲ, ಈಗ 23rd ಕೇಸ್ ಇದೆ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬೋದು ಮಂಡೇ, ಎರಡೂನು ಒಂದೇ ಸರಿ ಹಾಕೊಂಡ್ರೆ.
Tag this petition along with so and so.
3408.
617 rejected.
ಅಲ್ಲ, ಡಿಫೆಂಡೆಂಟ್ ಅಟ್ ವಾಟ್ ಸ್ಟೇಜ್ ಹಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್, ಮೇಲೆ
What stage?
ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಆಗಿ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಆಫ್ ದಿ ಇಯರ್ 2015 ಮೇಲೆ
Partition.
ಅಲ್ಲ, he has admitted several. I'll bring it to your lordship on Monday, my lord.
Partition stage ಇಲ್ಲ.
ಅಲ್ಲ, on Monday, my lord, 23rd ಕೇಸ್ ಇರೋದು. ಅದು ಈಗ ಅಪ್ಲಿಕೇಶನ್, ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ, ಅದ್ರಲ್ಲೂ ಒಂದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಅಲ್ಲ ಸ್ವಾಮಿ, ಬೇರೆ ಬೇರೆ ಅಲ್ಲ.
ಕ್ಲಾರಿಫಿಕೇಶನ್.
List this matter on 23rd along with so and so. Tag this petition. Further proceedings before the concerned court shall remain stayed.
Because, my lord, because he has filed the.
Partition very clear. 617.
On that day, both the petitions can be disposed of, my lord. ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು 23rd I will not precipitate the suit, my lord. On that day stay ಆಗದ್ ಬೇಡ ಸ್ವಾಮಿ. 2015 matter.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ, he has already filed it several. He has played the fraud.
23rd, yes. Preliminary hearing.
Stay ಅಂತ ಬೇಡ ಸ್ವಾಮಿ, because on 23rd ಕೇಸ್
ಏನಾಗಲ್ಲ, ಅಲ್ಲಿವರೆಗೆ ಇರ್ಲಿ. ಅವತ್ತು ಮುಗಿಸೋಣ.
ಅವತ್ ಮತ್ತೆ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಇದೆಲ್ಲ ಮಾಡ್ತಾರೆ.
Preliminary hearing ಅಂತ ಹೇಳಿದಿರ. ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ಇವರೊಬ್ಬರೇ ತಾನೆ?
ಅಲ್ಲ,
ಅದರ ಸೈನ್ ಬೇಡ. ಮೆಮೋ ಹಾಕಿದ್ದೀರಾ? ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್ submits that notice to other respondents be be
ಅಲ್ಲ, even
dispensed with.
21st ಹಾಕೋಬಹುದು ಸ್ವಾಮಿ, ಅಂತ
Dispensed with,
dispose.
yes.
ಅಲ್ಲ, ಸ್ಟೇ ಬೇಡ
23rd.
ಸ್ವಾಮಿ, 21st ಹಾಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು.
No problems. Yes, preliminary hearing ಅಲ್ಲಿ ಬರುತ್ತೆ ಬನ್ನಿ. Next.
Written statement is rejected.
ಅಲ್ಲ, additional issues permitted.
Yes, my lord.
617 rejected.
Yes, my lord.
Yes. The petitioner is before this court calling in question, but suit is of the year 2012. Additional
Yes.
issues ಯಾವಾಗ ಆಗಿದ್ದು?
Additional issues ಆಗಿ subsequently, my lord. I
And
had,
when?
Lord.
Dates ಬೇಕು subsequently ಅಂದ್ರೆ ಆಗಲ್ಲ.
my lord, additional issues are 24th of July 2024.
The petitioner is before the court calling in question an order dated 17/4/2025 which rejects an application filed by the petitioner under Order 6 Rule 17
This is for additional written statement.
for additional written, sorry, under Order 14 Rule 5. ಏನದು?
Order 8 Rule 1.
Order 8 Rule 1 for filing of additional written statement in the light of the additional issues under Order 14 Rule 5 being excised by the concerned court. This comes to be rejected, notwithstanding the framing of the additional issues. Therefore, there shall be an interim order of stay for the proceedings before the concerned court till the 30th, list on 30th.
We permitted to serve the counsel.
Petitioner
as-
to serve the counsel who represents the respondents plaintiffs before the concerned court and file an acknowledgement. Next.
Grateful.
My lord, I'm for the petitioner, my lord. My lord, the petitioner seeking setting aside the order of this trial court, waste number 26 on the my lord. My lord, the petitioner has filed the WP number, my lord, WP number.
WP?
Please, my lord.
What WP?
My lord, the tenants have filed the WP before this court, my lord, WP
Which
number. my lord,
WP is that?
7401, my lord, Annexure E, page number 4041.
ಏನಾಗಿದೆ ಅದು?
This court interim order, the tenants went to my lord, this court, the granting a show, the stay out of the show, the regarding the issued bank, the regarding sale notice. Now
ಸೇಲ್
the-
ನೋಟಿಸ್ ಸ್ಟೇ ಆಗಿದೆ.
Please note it.
ಸರಿ,
Now
ಅದಕ್ಕೆ?
the respondent had filed a suit against the petitioner, my lord, for injunction regarding so the property in question. The trial court can interim order, my lord, 19th December 2024, page number 64, my lord, 62 it is.
All right.
Now, the writ question also state the, on the same matter, my lord, so the say, the court also got an interim order.
ಈಗ granted an interim
Please
order.
notice.
You are the defendant.
Please notice.
File an appeal.
Well, my lord, when the parallel proceedings is going on, my lord.
File an appeal.
It is going on also.
No, no, God, it is not going on anywhere. Yes.
Like, hearing, not hearing.
File an appeals.
The interim
Order,
not.
there is an order against you.
Please notice.
File an appeal.
When the suit is pending for.
No, no, sir. File an appeal if you want to file, yes. The petitioner is before this court.
Regarding, appeal is pending, my lord. There is no appeal, my lord. There is no appeal pending. The suit is pending.
File ಮಾಡಿ sir appeal ಅದು order ಮೇಲೆ. The petitioner, you are the defendant.
Defendant, my lord.
And the petitioner is the defendant in suit instituted by the respondent plaintiff. The concerned court in the said OS grants an interim injunction under Order 39 Rule 1 and 2. Challenging the same, the petitioner is before this court. The ground on which the ground that the petitioner projects is the property which is the subject matter of the suit is pending consideration in WP zones. ಯಾವ page ಅದು?
7509, my lord. 7509.
Page ಹೇಳಿ.
Page number 42, my lord, it is.
In which there is an interim order of stay directing the bank not to auction the property of the petitioner. That has nothing to do with the subject suit. If the petitioner is aggrieved by the order of grant of injunction under Order 39 1 and 2, it is for him to prefer an appeal before the first appellate court. Reserving such liberty, if he so desires, the petition stands disposed. Next.
75.
But my application for amendment seeking declaration has been rejected by the court only on the ground of delay, my lord. 2017 is the suit. 2018, they filed the written statement. 2019, issues are framed. 2020, my lord, I filed the affidavit evidence. Then 2022, I filed an application for amendment because they are contending that they are the owners.
Yes, sir.
Lord, if the suit.
What
cannot-
applied to you there applies here.
Yes, my lord. Only thing is, my lord, limitation here, my lord.
What limitation?
My lord,
ಎರಡೂವರೆ ವರ್ಷ ಕೋವಿಡ್ ತೆಗೆದುಬಿಡಿ.
my lord, we have suit, my lord.
Suit 17, issues 19,
Yes, my lord.
20 COVID,
My lord, my sale deed is.
2.5 years after that.
Yes, my lord. My sale deed
Amala.
is of the year 2005-6.
That's all right.
So
We
therefore,
are
if
on
there,
617 rejection.
if the suit, my lord, is brought about in relation to a sale deed of, my lord, 2005-6, then, my lord,
Can document produce, amend ಮಾಡ್ಬಿಟ್ರೆ suit ಗೆದ್ದಂಗ. It is rejected on the ground of delay. Delay on the face of it is not.
it may not be delay, my lord. Delay.
ಅದು
only
ground ಅದೇನೆ.
Only limitation, my lord.
That is the ground.
Limitation, my lord, is the ground.
Limitation for what?
For challenging the sale deed, my lord, if the amendment.
What is the amendment now sought?
For declaration of.
that I am the owner of the property. and
What was
for
the suit initially filed?
Injunction, injunction.
Bari injunction ಹಾಕಿ.
Yes, my lord.
And I did
Therefore,
not amend any of the averments, my lord, only then the relief.
One, trial has commenced, my lord. PW2 is, my lord, sought to be.
PW1, my lord.
Well, that's all right. Now you want to convert this to declaratory suit.
Declaratory suit.
Declaration seeking what?
That I am the absolute owner of the property and for a declaration that sale deeds.
Which sale deed of what date?
Sale deeds of 2005. My lord, what happened?
2005-6.
What happened was, my lord, there was a power of attorney. In the power of attorney, the sites are not there. They got the sale deed. Therefore, I have challenged it because that power of attorney was sent to forensic and they found, my lord, it is fabricated. And
Yes,
therefore, my lord,
you're on fraud.
My lord, yes, my lord. I am on fraud. And the question is, my lord, whether power of attorney contains those two sites.
Where is the pleading in the application?
There is no pleading.
My lord, pleading
With regard to fraud ಎಲ್ಲಿದೆ?
No.
fraud illa, pleading illa. That's
ಅಂದ್ರೆ
why I
case
am only
fraud ಇಲ್ಲ
seeking
ಅಂದ್ರೆ
for-
case ಇಲ್ಲ.
I am only kindly take this judgment, my lord.
No,
Even-
no, sir.
Even if there is a delay, kindly take this judgment, my lord.
2005 sale deeds will not permit by way of an
Kindly
amendment.
take this judgment.
No, what you cannot do directly by filing a suit because of it, you can't do indirectly by 617.
Yes, my lord, that is
Yes.
what.
My lord, the question is, my lord,
Question ಅಷ್ಟೇನೆ.
my lord, whether their sale deed gives them the title to the property, my lord, ultimately I have to
Forget
prove
about
my-
that, sir. You are in now a declaratory suit cannot be filed because of the delay. 2005 sale deed, there is no fraud even alleged here.
My lord, I can file a suit for declaration, my lord.
File.
That is why, my lord, kindly see this
File
statement.
ಮಾಡಿ,
That is why
amendment will not
Supreme Court
permit.
says, even after 11 years, the amendment can be allowed. The delay cannot be considered at the time of amendment. It is a matter for the trial court to consider at the time of evidence. Kindly take this judgment.
Prima facie, what cannot be done directly cannot be
Kindly
done
see
by
this
way of an
judgment.
amendment. What is the judgment?
My lord, 2001, if the suit is not maintainable, challenging that question of allowing the amendment will not arise.
Kindly see this judgment. Kindly see this judgment.
I guess it is-
Paragraph number 11.
I guess it is rudimentary.
No, my lord, kindly see this judgment. Para 11. Para 11. In the present case, the amendment is being sought for almost 11 years after the date of institution of the suit. The plaintiff is not debarred from instituting a new suit seeking relief of title and recovery of possession on the same basic facts as are pleaded in the
I
plaint.
can, my lord,
Seeking
intervene.
relief of
That
issue
was,
of-
my lord, 12 years for the filing the suit for possession was not barred, which is why the amendment came to be allowed. That judgment goes in my favor. There, what the Supreme Court says is you could have filed another suit because it is one for possession, limitation is for 12 years. So therefore, I am allowing the amendment even though there is a delay of 11 years. Precisely the point that we are
What
canvassing.
the court is saying, merits of the amendment sought to be incorporated by the amendment are not to be judged at the stage of allowing the prayer for amendment. So therefore, my lord, whether I am entitled to that relief or not, court will have to decide, my lord, having regard to various other factors also. So
Let's see.
therefore, amendment cannot be rejected merely on the ground, my lord, that relief which I am challenging, because I am not saying that sale deed will have to be cancelled. I am only seeking a prayer that it is not binding on me. Because that
ಎಲ್ಲ ಒಂದೇ.
particular sale deed, my lord,
ಎಲ್ಲ
my lord, that particular sale deed is on the basis of power of attorney. Power of attorney did not
Ingenious
con-
submissions will not give way, sir.
my lord, that power of attorney on the basis of the sale deed was made, did not contain these sites, my lord. The power of attorney has been created and it is subject matter of criminal proceedings where FSL report has come.
That's not your
Therefore,
ground.
my lord, the amendment,
If you want, you file a separate suit.
my lord, with liberty to file a
Then I
separate-
will not say anything, sir.
my lord, this suit will come in the way, my lord. This present
They
claim
will not give you any.
will come in
liberty.
the way, my lord.
No, no. Sir.
My lord, as on the date of 2016, my lord, kindly see, my lord, 2016 suit for injunction is filed. They filed only in 2018, my lord, the written statement. Then only I came to know about this sale deal. Till then, I did not know about the sale deal.
When was it filed, written statement?
2018, my lord,
When did you file the application?
2022, my lord, after the COVID.
After COVID.
My lord, during COVID, my lord, I
ಅಲ್ಲ,
let in
ಕೋವಿಡ್
evidence.
ಕೋವಿಡ್ ಹೇಳೋದಿಲ್ಲ.
ಅಲ್ಲ, COVID ಬಿಡಿ,
Yeah, my lord,
COVID
in the-
ಬಿಟ್ರು, this has something hidden here.
2005 sale deed, my lord.
But I did not know, my lord. That is
Lord.
why I challenge, I sought for
No, that is
amendment.
only if you have alleged fraud. Otherwise, limitation would spring.
One more.
That's my view, we'll see.
Okay.
Yes,
Pudi.
my lord.
Heard, yes.
Learned friend has got one later judgment of 2017. We'll give
Illa
all.
kodi.
1995 and 2017. This new suit cannot be maintained, question of allowing the amendment.
Good.
Yes.
Please.
This is
Very
one
Because
judgment.
I was also of the view
Gives
that
complete, my lord, what are the factors to be considered by the court? 2000, maybe I don't know.
we'll do it, yes. ಯಾವ್ದು ಕೊಡಿ ಅದು?
2017.
Yes,
ಅದೇ-
Chakreshwari.
ಅದೇ.
My lord, as long as no prejudice is caused to the other side, they have the
Prejudice is going to be caused.
Lord, they have the opportunity to cross-examine the
We'll
witness.
see, we'll see.
Blood,
Yes.
it can be allowed.
Heard, reserved, yes.
76.
Even later judgment, my lord, which in relation to rejection of plaint, where the Supreme Court has said if it is registered, explanation 3 to the Transfer of Property Act says that the registered instrument, you have deemed to have knowledge. So he deems to have knowledge from 2005.
ಅದು ಕೊಟ್ಬಿಡಿ.
And ಕೊಡ್ತೀನಿ, I'll just give it to the court office.
Yes, yes.
56.
RA pending. Regular appeal is pending.
It's been more than a year we have filed ARIA and.
Petitioner to serve on the council who represents the respondents before the respondents before the concerned court. Lest this matter on 30th, further proceedings before the concerned court shall remain stayed. Next.
77.
Here for the respondent.
12A compliance ಆಗಿಲ್ವಾ?
ಎಲ್ಲ ಆಗಿದೆ. My lord, what has happened is final arguments 3 ದಿವಸ ಮಾಡಿದ್ದಾರೆ. 40 ದಿವಸ ಎವಿಡೆನ್ಸ್, 150 my lord hearing. If your lord says, my lord, just take. ನೋಡಿ.
What is the order? What is the order under challenge?
Order 7 rule 11 has been rejected. Issue, my lord, if your lord says, look at my lord, the issue. Issue frame, my lord, please come to 16. Sorry, my apologies.
Password.
Sorry.
Password, yes.
My apologies.
78.
You are not the owner is a matter of evidence. I will not interfere. You can't escape like that.
Document as, the
Oh,
original
no,
owner
sir,
as
let
a
the
part-
court consider.
the original owner, later stage, is the part.
That, all that is a matter of evidence. Will not consider.
Subsequently is the party.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಲೈಬಿಲಿಟಿ ಬರದೇ ಇಲ್ಲ ಬಿಡಿ ಅಲ್ಲ ಅಂದ್ರೆ ಬಟ್ ಐ ವಿಲ್ ನಾಟ್ foreclose it. The petitioner is before this court calling in question an order dated 21/3/2025 passed on IA number 2 filed by the present petitioner in MVC 325 of 2018. The contention, the application, the petitioner is respondent number 1 before the concerned court, said to be the owner of the vehicle, which meets in a road traffic accident. Compensation is claimed at rupees 26 lakhs joint and several against the owner and the next year owner and another
Previous one.
person. The petitioner prefers an application on order 1 rule 10(2) before the concerned court seeking his deletion from the array of defendants on the score that he is not the owner of the vehicle. This would undoubtedly require evidence. The concerned court has, by rendering cogent reasons, rejected the application filed by the petitioner owner of the vehicle. It is one of the vehicle, finding no merit to entertain the subject petition or perversity in the order of the concerned court, petition stands rejected. ಅಲ್ಲೇ ಮಾಡಬೇಕು. Yes.
79.
ಈ ಕೋರ್ಟ್ ಫೀ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಒಂದು ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? Heard the learned counsel appearing for the petitioner. The petitioner shall serve on the counsel who represents the defendants. Contesting ಯಾರು?
Contesting 2, 7 and 8.
Uh,
1, 2, 7 and 8.
Defendants 1, 2, 7 and 8. Counsel representing 1, 2, 7 and 8 before the concerned court. 30th, further proceedings shall remain stayed till the next date. Next.
80.
Appearing for petition.
Order 22 rule 10 rejected.
Allowed. Allowed, my lord. The page number 28 annexure
ಏನ್
D.
problem?
Problem is, that page number 28 annexure D. So respondent number 1, A.K. Manjunatha and 1 Iramma have filed a suit for partition. Page number 28 annexure D. Iramma has expired.
Expired. Iramma?
Iramma has expired. Iramma is the mother of the petitioner and other defendants. The respondent number 6 to 7 have filed an application claiming that Iramma has executed a will. So he has filed an application to come as a assignee of the Iramma. Under the will, he has to obtain a probate and have to establish his right over the property. Without getting a probate before the competent civil court, he has filed an application to come and.
We are contesting illi.
6 to 8.
Petitioner to serve on the counsels who represents the respondent 6 to 8 before the concerned court and file an acknowledgement. List the matter on 30th. Further proceedings before the concerned court shall remain stayed.
My lord, notice to other respondents may kindly be dispensed except 6 to
Memo
8.
kodi. Counsel for the petitioner files a memo seeking dispensation of issuance of notice qua the other respondents. In the light of the memo, so and so. Next.
81.
Appear for the petitioner.
ಏನು legal notice ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ?
Please, same matters, same subject matter.
That acts as a bar?
But not the, because otherwise, I give instructions, it
petitioner.
may be misused.
Plaintiff ಮಾತ್ರ serve ಮಾಡಿ ಸಾಕು.
Please.
The petitioner shall serve on the counsel who represents the plaintiff first respondent before the concerned court and file an acknowledgement to that effect. The issue is the counsel representing the first respondent plaintiff. It is the averment in the petition that the first respondent plaintiff is represented by an advocate who had issued a legal notice in favor of the present petitioner.
In respect of the same subject.
In respect of the same subject matter. In that light, further proceedings before the concerned court shall remain stayed. List on 30th.
Please.
Next.
82.
Lord, I appear for R1 to 14.
Petitioner in this matter. I am the plaintiff in the trial court, Lordship.
What's wrong with the application being allowed?
Lordship.
Suit for?
Suit for eviction of.
In fact, they are party to our suit as well.
Eviction and recovery of arrears of.
Why have you made them parties? In your suit, why have you made them parties?
No, Lordship.
All right.
Suit schedule property is already adjudicated before the Supreme Court and stated that petitioner is also one of the owner. They have no right to come on record, Lordship.
Lord, there are 4 separate litigations in which we are involved.
It is suit schedule property. Kindly see the.
What is this?
I have not seen this.
One
copy kodi. List on 16th and preliminary hearing. Yes, next.
83.
And in this, by playing fraud on the court, they have obtained an order.
What order?
Plainly, annexure B may be seen.
How do you say it is playing fraud?
Right, I was a party before the court originally. They file amended, advance the case, file amended petition, excluding me. Then they compromise. Kindly,
First, show me you are a party.
page number 90, ink page 19, madam. Ink page
19.
19, that is the original petition.
Madevamma.
Yes, madam. 4, respondent number 4.
Deletion.
Kindly turn to page
What
number
was this
23.
suit? What was this suit for?
Partition.
They exclude you in the FDP. Yeah?
FDP, I was there. When they file an amended petition, which is at
Where
page
is it?
23.
Page?
23.
Oh, they exclude you.
They exclude me.
And
Then
compromise.
they compromise on the very same day. When they advance it, file amended petition.
The petitioner, the original fourth respondent in FDP 7 of 2016 arising out of OS 307 of 2012 is before the court alleging fraud played by the plaintiff and the other defendants in the FDP. He would submit that in the FDP originally filed, she was the fourth respondent. An amended petition comes to be filed before the concerned court, excluding the present petitioner, and on the same day, a compromise is entered into between the parties, leaving out the rights of the petitioner. In that light, there shall be an interim order as prayed for till the next date of hearing. List on 25th. Yes, next.
84.
I'll notice ಯಾರಿಗೆ ಮಾಡಲಿಲ್ವಾ? Notice ಮಾಡಿದೆ. Petitioner shall serve on the counsel who represents the respondent before the concerned court. The petitioner 2610A is permitted.
Permitted before his conclusion of his evidence.
Correct, yes. The petitioner is before this court calling in question an order dated 19/4/2025 passed on IA 9 in OS 850 of 2014. The learned counsel Manmohan PN representing the petitioner would take this court through the documents under the petition to demonstrate that at the fag end of the trial, at its conclusion, an application under Order 26 Rule 10A comes to be filed seeking the signatures to be verified. Disputed signature.
Disputed signature. He does not lead evidence.
Seeking the signatures to be referred to an handwriting expert without at the outset leading evidence on the said issue. In that light, there shall be the order dated so and so shall remain stayed. It is made clear that the trial is not stayed.
Please. Yes, next. That is 850 of 2017. It's typo error year. I'll just correct it.
Yenadu?
Year of the suit is 2017. ಅದು 14 ಅಂತ ಆಗಿದೆ.
17. Anyways.
Can I correct it?
Stage ಎಲ್ಲ ಸರಿನಾ?
Stage in the sense not his cross exam. Now it's for the purpose of
right, yes,
appointing
next.
the expert.
We'll see.
Please.
85.
For the, sorry.
Petitioner.
ಎಷ್ಟು ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು ಸರ್?
150 ಕೋಟಿ ಇದೆ.
150 ಕೋಟಿ.
ಅಲ್ಲ, it is my money which is in nears to my
money.
My share, my lords. My share of the rent is deposited. I file an application that it should be released. Lord, the trial court.
ಬಿಡದಾ?
No, lords, they have not sought for any interim order. We will file our formal counter, lords.
ಇದು application ಮೇಲೆ ಬಂದಿರೋದಕ್ಕೆ interim order.
I do not know what ಅಲ್ಲಿ we are saying, like file our formal
petition suit ನಾನು stay ಮಾಡಿಸ್ಲಿ ಅಂತ ಕೇಳಕ್ಕಾಗತ್ತಾ? I cannot do that.
Very fair. Yes. Heard the learned counsel KB Manish Kumar appearing for the petitioner and the learned. Yeah, why all right?
Because of the
the amount.
No. To face Mr. Manish. Face him, it is.
I am hiding behind my lord. It's different.
Yes. ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರು. And the learned senior counsel Prabling Nawadgi and C.K. Nandakumar appearing for the respondents. The learned counsel, both the learned senior counsel and unison would seek time to file statement of objections. 25th ತಗೊಳ್ಳ?
They themselves come up before the court.
25th.
There is a direction issued that you deposit there. They deposit it in my
ಆಯ್ತು,
account.
objection
They want
ಹಾಕಿ.
to object, my lords, my withdrawal.
No, there is.
Where
it has
are
got
they,
a-
please, my lords?
It has got a
My
different
submission.
conspectus, but I'll bring to lords.
Can it be, my lords, that they will deny me that they deny the title? They're denying the title, my lord. Why did they
He has
enter
filed a
into the-
criminal case against me.
That I will do, please, my lord. I'll
No,
have
he
to
has
do it.
filed a criminal.
Argument
Don't, I
after
will have to do it.
adjournment.
I will
No, I
prosecute.
only
What
bring-
argument after adjournment? Yes. 25th, yes.
86.
Income statement is allowed, my lordship. The uncorrected documents produced by the defendant. That's why after lapse of 12 years, my lordship.
The petitioner is before this court calling in question an order passed by the concerned court. Mute ಮಾಡಿದ್ದು. Order passed by the concerned court by which the application filed by the defendants under Order 6 Rule 17 comes to be allowed. An application that is preferred after 12 years of the institution of the suit and 10 years after 12 years of the suit and 10 years after filing of the written statement. Partition. Partition is kashta anyway. So list the matter on 25th. Petitioner to serve on the counsel who represents the respondent in the trial proceeding. Next date, 25th. Next. Yes.
87.
My lord, 87, I am appearing for the petitioner, my lord. My lord, our impugned order is at page number 98, my lord.
ಆಯ್ತು ಪ್ರೊನೌನ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು ಪ್ರೇಯರ್ ಏನು?
My lord, prayer is to recall plaintiff for further cross examination. That application was dismissed by the trial court, my lord.
Rightly dismissed.
Without looking into the matter, that
What
my lord,
matter?
the earlier order has been allowed the same application.
Who had filed?
My lord, 98, page number 98, IA number 46 to 49 filed by the defendant 4 and 5 under so and so, dismissed or rejected with the cost of rupees 800. My lord, these applications are filed on 10/9/24. Order sheet dated 10/9/94 is at page number 8, my lord. Page number 8, extracted in the writ petition itself. My lord, matter is called out to parties to are present. Learned counsel for defendant filed application under Order 18 Rule 17 Section 151 so and so and so. IA 46 to 49. Application filed to reopen and recall applications is allowed. Learned counsel for the D6 praised.
Sridhar sir, 1 minute. The petitioner shall serve on the counsel who represents the plaintiffs 1 and 2 before the concerned court and file an acknowledgement list on 30th. Further proceedings before the concerned court till the next date shall remain stayed. Next.
88.
Much obliged.
Pass over. Passed over. Pass over. Yes. Not ಜಾಸ್ತಿ.
89.
Partition.
No, not partition.
SV Prakash. Oh, yeah, sorry, sir. Yes, yes. 617.
Secretary himself is not
Minister. ಏನಾಯ್ತು ಹೇಳಿ?
What happened is, he filed first April 2018. On 26/5/2021, issues were pending. Evidence was given from 27/7/2021. Was examined. And they took time to cross-examine figure 1 and 2. Up to 25/3/2025. The secretary may not die. The defendant represented the secretary died. And 2 trustees were not on record in this case. And they filed additional constraints. On 27/11/2025. They also know after the suit was posted for defendant page 116, an application was made for amendment of the suit. And there is no explanation as to the proviso to Order 6 Rule 17. That despite their
Due diligence. ಬಟ್ ಇದು 10 ವರ್ಷ ಎಲ್ಲ ಅಲ್ವಲ್ಲ? ಯಾವ issues frame ಆಗಿದೆ ಯಾವಾಗ?
issue 21,
ಮತ್ತೆ
26/5/2021.
on that ground you have a weak case.
After the commencement of hiring the student, but application can't be allowed in usual. Less,
ಅದು proviso.
yes, but there is no consideration of, there is no explanation at all in the observed file in support of the application.
Page. Page.
Page 116. And it is unnecessary, there is no action of allowing this type of amendment. Page 118.
Partition suit, declaration.
Declaration sale deed is obtained by fraud and. Without authority.
Yes, sir.
So amendment.
Your lordship, when we see this authority 118, that was filed by one of the trustees representing the defendant. And there is no such, but what it is said, it gave 120, all these amendments are necessary to give a clear.
What is the amendment now sought, sir?
Amendment is to add, para 18, they wanted to say that, after it is also true that the government, this is what they have stated originally in para 18. They want to say that while passing the conversion, but I don't have much objection to this. But they want to another amendment to paragraph 18 to say that conversion fee was returned and paid back to them. This is contrary to what they have said, page 117, what they said in original reconstruction. They cannot take away the admissions given in the original reconstruction. Then they want to add extra paragraph 18.
Right, ನೀವು objection ಹಾಕಿ. You want to file objections, file.
Amendment is written statement.
ಅಲ್ಲ ಈಗ fraud or forgery ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಂದ್ರೆ now the government has directed the deputy commissioner to grant conversion. That was page number 116 of amendment. First amendment will directing the deputy commissioner for conversion. Government cannot grant a conversion. It has directed the deputy commissioner to grant conversion.
ಆಯ್ತು.
Second, the entire amount which they have claims to have deposited to the deputy commissioner for conversion has been withdrawn. But in the plaint they have stated that they have deposited this amount and that amount has been withdrawn. That is a matter of fact and for which document has been produced. No, the challan and everything that government has paid through on challan only the amount which the plaintiff has deposited towards conversion fee. That is what, and one more amendment, paragraph 117 page, paragraph 4, we denied that the management committee has no power to deal with this removable property, but we have admitted that clause has been denied. So all these amendment will not take away any right of the plaintiff in any manner.
Judgment ಇದೆ ಬಿಡಿ, ಎಲ್ಲ ಕಡೆಗೂ ಇದೆ, ನಾನೇ ಕೊಡ್ತೀನಿ ನಿಮ್ಗೆ, ತೊಂದರೆ ಇಲ್ಲ. Nature of this suit, admissions cannot be taken away. ಏನು? Your due diligence, I know, sir. Tell me. Yes.
There must be application of file on the part of the defendant. Why we not need to allow an amendment after the as in the suit commence.
ಈಗ ಏನ್ ಆರ್ಡರ್ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಇಲ್ವಾ?
No, there is no.
Where is the order? Where is the order, sir?
There is nothing.
Page, wait, sir.
There is only the reference to the documents related upon the partition, reason 131.
136 page 23 ma.
And then the reference to the citations related upon the respective counsel. Then we learn that passes the order allowing the application for everything consideration of the provider to order.
Anything else?
But my suggestion is, if these applications are allowed.
ಏನು? Usual course ಏನಿಲ್ಲ sir. I am also strict in permitting, allowing after the commencement of the trial. It is not an absolute bar. Due diligence also I will answer. No problem.
There must be an explanation offered by the applicant.
Where is the explanation in the, where is the application?
The application is
Nura 16 page.
Nura?
Page 116, page 116. Affidavit,
Hmm.
is 118. Because this other one, this proviso becomes redundant.
No, sir, don't worry about all that. I will answer all that. I have yesterday or day before yesterday rendered a judgment with regard to due diligence. If you have not seen, I have carved out exceptions there. Nothing. Yes, yes. That's all right, sir. No problem.
Application was made 4 years thereafter.
No problem.
After police, what happens, I have closed my evidence. I have closed my. Now they want to introduce something, certain new facts. But how I will answer that after my evidence is over?
Yes. Anything else? 18A introduce ಮಾಡಬೇಕಾಯ್ತು ಅಂತ.
18A they want to introduce a new paragraph. And they want to say something, according to them, it's a non-agricultural. They want to know content that conversion fee they have paid, they have deposited, was returned back, and therefore it is not a non-agricultural.
Now, who sought conversion?
It was converted earlier,
Where?
application made by them, it was converted.
No, you are the plaintiff.
No, I am the plaintiff.
All right. Now, the ground is that it is an agricultural land.
Yes.
It continues to be an.
Agricultural land. This is a society which under 1960. Society which is at 1960. The earlier committee, headed by from chairman, he was occupied that seat for 24 years. He never conducted the meeting of the managing director.
ಅದೆಲ್ಲ ಆಯ್ತು ಇದಕ್ಕೆ ಹೇಳಿಯ.
So what he sold without permission of the managing committee, contrary to by law. He sold the valuable property of the institution to the defendant. And after the new committee, what happened is government noticing this fact, superseded the committee under section 47, and election was conducted by the administrator. After the new committee took over charge, after they came to know about this facility, under which these valuable properties of the institution society sold for what is some. Then this move was back, saying that the facilities are not binding because the person who sold it had no authority at all to sell the properties. That is what we have attended the time.
Now 18A is being introduced. Government orders ಮಾತ್ರಕ್ಕೆ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಏನು?
Government order.
ಏನು government orders ಆದ್ರೆ ಇಟ್ಸ್ ಓಕೆ. ಬೇರೆ ಏನಿದೆ?
Let's say he wants to introduce by way of new paragraph. Then next item. At paragraph 20 of the business statement, right number 40.
Let's see. All these documents are earlier to the filing of the written statement also.
Yes.
We'll take it at 2:30. Continue at 2:30.
90.
Partition suit. 617.
Filed by the defendant for.
Anything else, sir? Oh, Kodi, sir. Yes. Correct. Now the court has rejected, is it? Yes, sir.
He cannot seek amendment of the plaint.
Why?
Because he is a defendant. It is my domain to add the property or.
You're asking amendment of his plaint, is it?
Yes, that's true.
Yes. We'll continue at 2:30. ಅದು ಕರಿಬೇಡಿ ಸಾಕು.
ನಂಬರ್ 2 ತೋರಿಸ್ತಿತ್ತು ಇಲ್ಲಿ ಬರೋ
ಏನಾಗಿದೆ? Come at 2:30.
I'm moving, Lord, I'm sorry, my lord, I'm moving a memo. Matter pertains to court hall 8, my lord. Transfer matter, my lord. May I request for tomorrow, my lord.
Transfer matter. ನಾಳೆ ಬೆಂಚ್ ಇರ್ಬೇಕಲ್ಲ?
ನಾಡ್ದು ಆಗ್ಬಿಡುತ್ತೆ ಸರ್.
ಏನ್ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
From Mangalore to Bangalore, my lord. The order is passed. Petitioner is an employee of corporation. Order is passed by the government, my lord.
Which corporation?
Karnataka Food and Civil Supplies Corporation, my lord.
That's covered.
Please, my lord.
Government cannot. Yes.
Please, my lord.
Premature na?
Premature ಇಲ್ಲ ಸ್ವಾಮಿ, but
ಮಂಗಳೂರಲ್ಲೇ ಇರ್ಬೇಕಾ?
no, my lord. May I request for tomorrow, my lord.
ಕೊಡಿ.
Please, my lord.
Madam Court Officer. Court Officer.
ಹೇಳಿ.
ಕೋರ್ಟ್ ಆಲ್ 8 ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗಿದೆ ಹೆಂಗೆ ಮೇಡಮ್ ಅದು?
2:30ಗೆ.
2:30.
Last time allow ಮಾಡಲ್ಲ ಅವ್ರೆ.
Settlement talks are on. Both the councils in unison would submit the talks of settlement between the parties are afoot, AFOOT. Okay. Huh? This is the matter on, we'll post it on Tuesday. Tuesday at 2:30 PM to report settlement. Interim order subsisting will continue.
Serial
Thank you,
number
sir.
142, my lord, it has become infectious because.
142.
142, serial number.
Call out ಮಾಡ್ಬಿಡಿ 2:30 ಇದೆಲ್ಲ ಎಲ್ಲ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿರೋದೇ ಲಿಸ್ಟ್ ಮಾಡಿಸಿರುತ್ತೆ.
Orders at 2:30 PM, 142.
The infractures
The impugned
suit
order,
dispose ಆಗಿದೆ.
the suit in which impugned order disposed is.
Is disposed, sir. Yes, correct. 143.
43.
Intermediate extension ಕೇಳಿ.
Huh?
Intermediate extension ಕೇಳಿ.
Infractures ಆಗಿಲ್ವಾ?
ಒಂದು ಡೆತ್ ಅಷ್ಟೇ ಫಸ್ಟ್
ಮೇಡಮ್ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತಾರೆ. ನೀವೇ ನೋಡಿ ಡಿಸ್ಪೋಸ್ as having become infractious ಏನಾದ್ರು ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ. Yes.
144.
Same order. Madam,
145.
ಇದ್ರಲ್ಲ 11 madam. Huh.
145.
Same. ಎಲ್ಲ up to ಎಲ್ಲಿವರೆಗೆ
6. 146.
up to 155 ಅಲ್ಲ madam?
My lords, in serial number 152, my lords, suit is disposed of, but the question in that matter, my lords, is there was some tampering in the original order sheet.
Suit dispose ಆಗಿದೆ ತಾನೆ?
Suit dispose ಆಗಿದೆ.
ಬೇರೆ ಏನಾರು ಇದ್ರೆ ಆಮೇಲೆ ಹಾಕಿ ಮತ್ತೆ. ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದ್ರಿಂದ ಕನ್ಸಿಡರ್ ನಾವು
Application ಅಲ್ಲ, the order sheet in the trial court, my lords, was
ಈಗ ಏನ್ what
tampered.
was under challenge?
The tampering of that order dated so and so was challenged before this honorable court, my lords.
What has happened to the suit?
Suit is disposed of, my lords.
Before filing of this, is it? After filing?
After filing of this.
Whatever liberty you want to exercise, you exercise in law.
Please.
Yes.
My lords, my name, I have filed Vakalat in
ಯಾವ್ದ್ರಲ್ಲಿ sir?
In serial number 152, my lords.
Registry to print the name of
Pavan G. my lords.
so Pavan G in place of HR Ananta Krishnamurthy.
Please.
Yes. ಆಮೇಲೆ
List number 2. First, non-compliance of officer objections. First time matters 1 to 30.
ಇದು ಫಾರ್ಮ್ಯಾಟ್ ಗೊತ್ತಾ ಮೇಡಮ್ಗೆ? ಒನ್ ಡಿಸ್ಪೋಸ್ಡ್ as having become infructuous. ಆಮೇಲೆ 2 to 30 withdrawal. ಕಿದ್ದು ಮೇಡಮ್ ಅದು ಫಾರ್ಮ್ಯಾಟ್ ಗೊತ್ತಾ?
Second time matters 31 to 44. 32 withdrawal.
32
Withdrawal.
withdrawal, yes. ಮಿಕ್ಕಿದ್ದು ಇದು ಸೇಮ್ ಆರ್ಡರ್ 10 days time. necessary to be allowed, notwithstanding the same, the concerned court has rejected it. There shall be an interim order of stay of further proceedings before the concerned court list on 30th.
93.
Rescission.
Rescission of contract, my lords. Suit was decreed in the year
Sorry.
My lord, with regard to exhibit P9, my lord, they only say that, my lord, it is served on the wife.
no,
Now they
P8
want to send the
my lord,
son's
P8
signature.
is a postal acknowledgement. In the course of the cross-examination of PW1, by mistake, he has said it is the signature of the daughter-in-law of the defendant. Okay, down below, my lord, your lordship may kindly.
What's the name? DW1?
DW1's name is Venkatesh.
ಎಲ್ಲಿದೆ ವೆಂಕಟೇಶ್ ಇಲ್ಲಿ?
Acknowledgement, postal acknowledgement.
Postal
ಕೆಳಗಡೆ.
acknowledgement.
Not received. That is also not his signature.
That is his signature. According to his affidavit evidence, he signs like that, Miller. His affidavit evidence is like that. And we are asking,
Has he accepted that he has signed on this document?
But we have disputed.
Miller, he will dispute it, Miller.
No, that's not his, sir. This
I am only
Veena
asking,
signature na
I
Venkatesh
am
Kendra.
asking this disputed signature to be compared with his affidavit's evidence signature.
ಆಗಿದೆ.
Not, we will deposit, not suppose if we succeed, not do we
ಎಷ್ಟು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಅಮೌಂಟ್?
44,600.
44,600 in 2000.
Now, not it is interest is calculated.
Correct. 44,600 ಯಾವಾಗ?
2008, not.
ಈಗ 17 years ಆಗಿದೆ. ಇವತ್ತಿಗೆ ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಇವತ್ತಿಗೆ ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
1 lakh.
1 ರಿಕವರಿ ಅಮೌಂಟ್ ಎಷ್ಟು ಸರ್?
ನಾ ಹೇಳ್ತೀನಿ ನಾವು ಮಾಡಿ
Decree 17 June 2019, you filed an,
back now
sir,
it is in
you filed an went back, ವಾಪಸ್
it was
ಹೋಯ್ತು,
went back was
no botheration, dismissed for non-prosecution,
that is
miscellaneous appeal attachment ಆಗೇ ಆಗುತ್ತೆ.
correct my lord. We will lordship may conditionally your lordship may
ಏನ್
stay.
condition?
ನಾವು not ಏನಂದ್ರೆ ಈಗ ಅಫಿಷಿಯಲ್ ಇದು ಮೂವಬಲ್ಸ್ ಆರ್ ಆರ್ಡರ್ ಟು ಬಿ ಅಟ್ಯಾಚ್ಡ್.
Oh, perfectly done. ಬೇಕದೆಲ್ಲ.
ಇಲ್ಲ ಇನ್ನು ಸ್ವಲ್ಪ ಒಂದು
Our officers behave like it's their personal fiefdom, so it is necessary.
no doubt my lord.
No doubt.
I am not that my lord your lordship may kindly grant my lord. The conditional order will whatever the amount is now.
What is the amount in due now?
my lord ಈಗ page 99 may kindly be seen my lord. 97 1,44,000 with interest 6% ಅಂತ ಇದ್ದಾರೆ.
ಡೇಟ್ ಯಾವತ್ತು?
ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್
ಬನ್ನಿ.
ಎಕ್ಸಿಕ್ಯೂಷನ್
OS ಗೆ ಹೋಗ್ತಿರಲ್ಲ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಲ್ಲಿ ಮಲೋಡ್ 37 lakhs ಮಲೋಡ್
37
ಇಲ್ಲ